headlines this week. I will begin with the former Chief Justice Torkonoo, who is back in court. This time, she's challenging her removal as a Supreme Court judge. The Article 146 committee found her guilty of stated misbehavior and recommended her removal as Chief Justice. But the president went a step further, dismissing her not only as the head of the judiciary, but also as a Supreme Court judge. Also this week, Asaase Ketia embarked on thank you tour in the Eastern region. Some say he's using the thank you tour to nurture his presidential ambition, but is there any truth to that? Or he's simply doing his job as national chairman of the governing party at a time when the party's or the government's popularity, according to an Imani report, is on a decline. We'll find out. Then again, pressure is mounting on the president to declare a state of emergency, but at last week's media encounter, the president said he's declaring a state of emergency should be the last resort. Does that position weaken the calls by UTAG, the Catholic Bishops' Conference, and the Coalition Against Illegal Mining? We'll be discussing all these issues here on the forum. You can join the conversation with your thoughts and comments. I'll read them as they come in. My name once again is Gemma Appiah. My guests will join me in studio shortly, but this week lawyers met in WA for the bar conference. The Attorney General Dominic Ayene was present and had a few things to get off his chest about the GBA's position on the suspension and subsequent removal of Torkonoo as Chief Justice. Wilberforce Asari will join us on Zoom to give us details. On Zoom now, Wilberforce, good morning to you.
Yeah, and congratulations on hosting the forum.
Wilberforce is the host of the forum today. I sacked him from his seat. I am here. Wilberforce, good morning. Good to see you. So let's get into it. What happened at the bar conference this week?
Well, so Gemma, the bar conference is, as you know, is an annual event that the members of the bar meet to discuss issues of national interest, find ways to make the legal profession more relevant to the ordinary Ghanaian. This year's edition was no exception. The conference focused primarily on how to sustain the democratic experiment that the country has been on the last 33 years, and the importance of the judiciary and the bar, which is lawyers, when it comes to that mission of protecting the democratic dispensation in our country. The leader of the bar, who is also the Attorney General of the Republic and Minister for Justice, spoke at that conference. The Ghana Bar Association President, Madam Ifwagate, also spoke at the summit. President Mahama was expected at the summit, but he did not make it in person. However, he sent a representative, Nana Oyelita. She's a deputy chief of staff and also a lawyer. And then the Chief Justice of the Republic, indeed the acting Chief Justice, was also supposed to be there. He couldn't make it in person as well. He sent a Supreme Court judge, Justice Amaleboba, to represent him at that summit. Essentially, if you look at the entire review, as I have heard some lawyers say and interact with, you would realize that the entire conference was about how to sustain a democratic experiment. But the Chief Justice's issue, as in the removal of a 7th Chief Justice, dominated the discussions at the bar conference. Some indicating that the whole process was unconstitutional, and others indicating that it was well within the rights of the president, the executive, to do whatever they have done. And so mixed reactions, but the bar president is widely reported to have said that the entire process was unfair, and that she believes that something ought to be done about the constitutional provision and the need to pass a constitutional instrument to regulate the use of Article 146 going forward in our jurisprudence and in the political space. So, Gemma, in a nutshell, that's what I can tell you about the bar conference, which passed just yesterday. And lawyers are renewed, looking forward to the commencement of the new legal year, which will be in about 15 days' time. So we're talking about 2 weeks from now. The new legal year should commence, and lawyers return to the courts to adjudicate cases that they were doing before the 2024-2025 legal year ended on the 31st of July 2025. Gemma.
Right, so let's listen to Dominic Ayene when he spoke at the bar conference this week, and Efwa Gate as well, and we'll come back and discuss further.
Our law lies in its service to society. If our practice does not make justice accessible to the market woman, the farmer, the laborer, and the vulnerable child, then we'll have failed our sacred duty to our country. The relationship between law and politics in Ghana has always been intimate. Lawyers were central to the nationalist struggle, drafting petitions, leading debates, and championing the cause of independence. Since then, lawyers have been indispensable in shaping constitutional governance, whether in drafting the 1992 Constitution, defending human rights in times of crisis, or mediating in moments of national tension. Yet, our role in politics must be guided by principle, not partisanship. When lawyers descend into the arena of raw politics without restraint, we risk undermining the very foundation of our professional credibility. We must remember that our allegiance is first and foremost to the Constitution and this Republic, not to transient political interests. Over 3 decades have passed since the adoption of our Constitution. During this period, our Republic has tested and continues to test the resilience of its democratic institutions. In doing this, the bar has played a crucial role in assisting the Supreme Court to interpret and enforce the Constitution. But outside the courtroom, the advocacy of the bar as a professional group has lacked consistency, bringing into question its adherence to principle. Ladies and gentlemen, when in 2015 an Article 146 petition was received by the Chief Justice in relation to the former chairperson of the Commission on Human Rights and Administrative Justice, Madam Lawuratu Musah-Saaka, the bar failed to speak out about process. In the run-up to the 2016 elections, the then opposition New Patriotic Party engaged the Electoral Commission in court battles over the voter identification system. This gave rise to the Abu Ramadan line of cases. Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The bar saw no basis to speak out about compliance with due process. But in recent times, the bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Araba Torkonoo. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The three petitions aforementioned touch and concern office holders of three constitutional bodies critical to the sustenance of our democracy. The independence of the three institutions has been guaranteed by the Constitution. The three occupants were all women of significant repute and members of our noble profession. The three committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the third petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen. The Ghana Bar Association is not merely a professional body. It is a moral compass of the legal fraternity and a key pillar in the construction of our constitutional democracy. As Lord Denning once wrote, and I quote, "Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased." The same applies to the bar. Our authority as a profession depends on public confidence that we stand above the fray of narrow partisanship. Let us therefore be the conscience of the Republic, fearless when governments overreach, impartial when opposition agitates, and always faithful to the sovereignty of the people under the Constitution.
The Constitution of the Ghana Bar Association enjoins us to protect the independence of the judiciary. This is a duty the association does not take lightly, and from time immemorial, the bar has fiercely performed this duty. My learned friends, we are all aware that Article 146 of our 1992 Constitution has come under severe scrutiny in recent times. For the first time under the Fourth Republic, it's being evoked in respect of a Chief Justice. The position of the bar must be stated clearly in this regard. The bar recognizes the fact that the power of removal can be exercised under Article 146, but the bar's major concern relates to the process. In the absence of specific rules of procedure, the sketchy process potentially lends itself to arbitrariness and a lack of fairness. Hence the bar's resolution on the matter, which was as follows. The Ghana Bar Association hereby also calls for the immediate enactment of fair and comprehensive regulations relating to matters under Article 146 of the Constitution of the Republic of Ghana to ensure transparency, accountability, and fairness in all proceedings involving Superior Court justice, particularly in the context of the impeachment or removal of such officers. This resolution was passed and publicized by 30th April 2025. However, no rules were produced. It is commonly said that justice should not only be done, but manifestly be seen to have been done. The lack of an enactment for such rules in the case of the removal of the fourth highest person in the nation should be a matter of concern for all of us. These rules should have been known to all and sundry before the commencement of the process, as it greatly affects the standard to be met. It ends up being an unfortunate precedent which lacks fairness, a situation that calls for redress if indeed we are custodians of justice. We all deserve justice, from the well-endowed in society to the less endowed, from those who wield political power to those who don't, from those who have economic power and those who don't, from those who dispense justice to those who receive justice.
So we just had the Ghana Bar Association President Tefo Agate, and earlier we heard the Attorney General Dominic Ayine. Wilberforce, what has been the reaction, the specific reactions of lawyers who were at the bar conference? Because we had the Attorney General who was very straightforward with what he had to say to the bar. The fact that he mentioned the bar found its voice when the petitions were brought against seeking to remove the now former Chief Justice Gertrude Torkonoo, and that they didn't find their voices at the time that Lawuratu Musah-Saaka and Charlotte Osei were removed from office as public office holders. How were they reacting to this comments by the Attorney General?
So yes, Gemma, very interesting question, and the reaction has been mixed. But I think that the most intriguing one has to do with the fact that most of the lawyers I spoke to are saying that the Attorney General was comparing two different things. He said that the removal of Charlotte Osei and Lawuratu Musah-Saaka were administrative positions and administrative officers. Indeed, their offices are equated to those of a Court of Appeal judge by virtue of the benefits they receive. But their offices, for all intents and purposes, were administrative offices. Now, they said that the position of the Chief Justice is a judicial office. And so the two can never be compared. And that the removal of administrative officers is an everyday activity. But the removal of a Chief Justice, who is the head of the third arm of government, cannot under any circumstances be compared to the removal of an administrative officer who is serving at a state institution. And that is the first difference that most of the lawyers were mentioning. Now, they also talk about the fact that the very fact that the Attorney General and the President of the Ghana Bar Association in their speeches dwelled mostly issues concerning the Chief Justice, emphasizes the importance and let me just use the word importance, the very importance of that process of the removal of a Chief Justice. They said that if her removal, that is Chief Justice Torkonoo's removal, was not anything important, why will the two main speakers at such an important event spend majority of their time discussing that removal and not any other matter? And that because of the importance that these two personalities placed on that process, it is the very reason why we need to give it a bit more attention as a country and to make sure that the mistakes that have been with this process are corrected immediately and not left to hang. Some also say that the current administration, which is the one that oversaw this removal process, will remain haunted by the process the rest of the history of our jurisprudence and our political space. And so these are some of the reactions that some of the lawyers have been speaking to, been saying about the bar conference. All in all, they conclude that the conference was successful and they are looking forward to next year's bar conference.
And that brings us to our next conversation, which has to do with the former Chief Justice Gertrude Torkonoo challenging the decision of the president to remove her as a judge on the Supreme Court bench. What is her argument and what release is she seeking from the court?
So, Gemma, yes, another interesting question. And if you look at the application filed by the former Chief Justice, Justice Gertrude Torkonoo, on the face of it, what she's seeking are clearly stated in 5 different paragraphs. So the first one is that she's asking for a declaration that the president is devoid of power to remove a judge or a justice of the Superior Court from office without recourse in the mandatory procedure set out in Article 146 of the Constitution. This is the first thing she's asking. The second thing she's asking is a declaration that jurisdiction to hear a petition for the removal of a justice of the Superior Court from office lies with a body properly constituted under Article 146(4) of the 1992 Constitution. 3, a declaration that the warrant of removal executed by the president dated 1st September 2025, purportedly removing the applicant herein from both the office of Chief Justice and office of the Justice of the Superior Court of Judicature is unlawful, null, void, and of no effect. And listen to the fourth one. an order of certiorari to bring into this honorable court the purpose of being quashed and for quashing the warrant of removal dated September 1, 2025, referred to in C above, and to quash same as being in violation of the mandatory provisions regarding the removal of a Chief Justice and the Superior Court of Judicature and the Justice of the Superior Court of Judicature from office. And the last one is any further orders as the court may deem fit to make. So for me, the government of the whole issue is on the last but one relief, which is the fact that the Chief Justice is asking the High Court to quash the warrant that was issued by the President for removing her both as a Chief Justice and as the Justice of the Judicature. The argument is that the process that she has been taken through was under Article 1466 of the Constitution. But there is a different process under Article 1464 for the removal of a Justice of the Superior Court of Judicature. And that process has not been followed. It has not been activated. It does not constitute. And so the process cannot constitute her removal as a Superior Court judge, but it may constitute her removal as a Chief Justice because the Chief Justice process was what was activated. So her contention essentially has to do with Article 1464 of the 1992 Constitution. And that is what the Chief Justice has sent to the High Court. Some people have asked why the High Court. And it's been explained that the body that was constituted by the President, it's an administrative body. So it is answerable to, or its decision can be reviewed by the High Court. And that is the reason why she's gone to the High Court for judicial review. Assuming the High Court does not respond to her request, she can go to the Court of Appeal to challenge the High Court decision. If the Court of Appeal doesn't agree with her, she can go to the Supreme Court to seek redress after the Court of Appeal decision. So that is the brief explanation that we need to put out there as far as the CJ's application is concerned.
Wilberforce, we also understand that she filed this application at the High Court on ex parte motion. True?
No. If you look on the face of the application, it says notice of motion, application for judicial review. So this application couldn't have been ex parte.
Right.
It was an application on notice. Yes.
Right. Let's look at the letter that the presidency wrote to her announcing her removal as Chief Justice. Now, in that letter, signed by the secretary to the president, it stated that in fact, the petitions were filed seeking her removal as Chief Justice, and that the committee had found her guilty of misbehavior, and so they had recommended her removal as Chief Justice. But the presidency said, let me just quote it, consequently, His Excellency the President of the Republic has, by warrant of removal under his hand and the presidential seal, effected your removal from office as Chief Justice and Justice of the Supreme Court of Ghana with effect from the date of the warrant. Is this where her argument really is?
Well, yes, so yeah, but that's where her argument is, because her argument really, from the face of the affidavit that is even in support of the application, will tell you that the Chief Justice is simply saying that the process that was activated by formation of the committee was for the removal of her from office as a Chief Justice. And so the process she went through was under Article 1466 of the 1992 Constitution. But if you look clearly in the Constitution, there's a different process in Article 1464. In Article 1464, it says that to remove a Superior Court Justice, you have to have 3 members of the judiciary or judges, Supreme Court judges, 3 of them, and then 2 other persons who are not members of Parliament, not lawyers, and also not members of the Council of State. But if you look at the process for the Chief Justice, it recommends 2 Supreme Court judges and 3 other persons who are non-lawyers, non-members of the Council of State, and also not members of Parliament. So that's where the difference is. To remove the Chief Justice, 2 judges. To remove a Superior Court judge, 3 judges. The committee that was constituted by the President was 2 judges and lawyers and non-members of Parliament and all that. And that is where her challenge is.
We were speaking to some lawyers shortly, but what have they been telling you about this new move by the former Chief Justice? She's still fighting on.
Well, so, yes, Gemma, good question. Most of the lawyers are saying that to develop our jurisprudence as a country, when matters like this arises, it is only proper to go to court for the court to make a pronouncement. When the court makes a pronouncement, it develops the law. So assuming that this is a gap, so that if you decided to remove a Chief Justice from office, you must also know that the Chief Justice, the Superior Court. And so when you are removing her, you probably are going to have to make it up of 3 Supreme Court judges and the 2 other persons recommended by Article 1464, which is about the removal of a justice of the Superior Court of Judicature, so that the process is 2 in 1, because the person is a Supreme Court judge first, and then the administrative head as a Chief Justice. You may have to combine the 2 provisions in the Constitution to form the committee for purposes of removing the person. But if you ignore one and do the other, then when you have finished with the process, you cannot let the process represent you cannot let the process reflect on the 2 activities, which is removal of a Superior Court judge and the removal of a Chief Justice. So the lawyers are saying that it is good that this application has been filed. Let there be a pronouncement connecting the courts. If she is not happy or satisfied with the High Court judge, she can go to Court of Appeal. If she's not happy with Court of Appeal, she can go to the Supreme Court. Even if she's not happy with the Supreme Court, she can still ask the Supreme Court to review its own decision. So the lawyers are saying that it appears this case is going to be a long haul. It's not going to end today. It's going to go on for a while because of the interest surrounding the whole issue. Gemma.
How does this help deepen our democracy?
Well, so the removal of the Chief Justice, according to various legal minds that we are talking about, we have been talking to, unprecedented. It's unprecedented because it's the first time it has happened under the 4th Republic. Now, under this 4th Republic that began in 1992 to date, we have had not less than 8 Supreme Court judges, not less than 8 Chief Justices. So I can talk about Justice Torkonoo, I can talk about Justice Sophia Kufu, Justice Nii Kpakpo. We can talk about Justice Georgina Wood. We can talk about, I believe, Archer and all that. So we've had about 8 Chief Justices only under the 4th Republic. And this is the first time a serving Chief Justice under the 4th Republic alone has been removed. We are told by the historians that such a process took place under former President Nkrumah in the 1960s. But from there till now, this is the first time this process has happened. And so people are saying that it is a dent on our democratic experiment for us to have taken somebody to the high office of Chief Justice only to use some petitions filed by some ordinary Ghanaians, some of which they are saying has no basis to remove her from office. They say it's an experiment, but they also believe that future governments can come and rectify this error and make sure that we learn from the lessons of these recent happenings, which took place essentially from the 22nd of April to the 1st of September. That's a period of about 6 months. That's when this whole process happened to result in the removal of Chief Justice Gertrude Araba Esaba Saki Torkonoo. Gemma.
Wilberforce, thank you. Oxford Osei Bonsu is a legal practitioner. He joins me now on Zoom as well. for us to talk more on this new application filed by the former Chief Justice Gertrude Torkonoo. Welcome to the forum, sir. Let me just get your initial reaction to this application.
Thank you, Madam Host, and good morning to your listeners and your viewers. Well, my initial view or comment about the application is, I would just say that it's within her right to, seek for such a redress. Of course, it is a safeguard mechanism provided for in the Constitution to protect institutions and then make sure that various institutions operate and work within their confinement or what their mandates are. So basically, once you feel that your rights are being crumbled, and then you believe that this is the application you need to seek to make sure that the right thing is done, I think that's good. And of course, it also strengthens our legal systems. So we will understand what kind of decision that the court will bring concerning that. So I think it's good. It's within her right, and it also brings some kind of calmness to the situation. Thank you.
It is well within her rights, but does she have a case looking at the argument she's making and that her application is premised on two grounds? One, the illegality and lack of power under Article 146 of the Constitution of the President's decision to remove her as Justice of the Supreme Court, and the lack of jurisdiction for the committee that recommended her removal as the Chief Justice to also recommend her removal as a Justice of the Supreme Court. These petitions were seeking her removal as Chief Justice, and per the letter that the Secretary to the President wrote to her announcing her dismissal, it mentioned that the committee had recommended her removal as Chief Justice. But the president went ahead to remove her both as the head of the judiciary and as a member of the Supreme Court's bench. Does this give her a strong argument in court?
Whether or not her argument is strong enough, it is the decision of the court to make. But then for us as lawyers, we don't preempt it, but we share knowledge and then digest in the matter. Basically, if you look at, I've not paid critical attention to the application's nitty-gritty of it, but I've seen it. And then if you look at it, whatever they are seeking the court to look at is the basis or the germane for that application, the judicial review. So what you have to understand is that when a committee is put together or commission acts or any of the agency of government act, they are supposed to act within certain threshold or within certain principles of the law. And so if you seek for that judicial review, what it means is that a specific committee or commission or government agency acted unfairly, or probably their act is ultra-virus to the Constitution, the principles of the Constitution. And then again, you also feel like through the process of acts, they actually, did things that, affected your fundamental human rights. And then again, as we know very well as lawyers, there's the substantive law and there's the procedure. And then the procedure is as good as a substantive law. So you cannot take one and leave the other. So it must so happen that whatever petition put against the Chief Justice might be, for want of a better word, there could be some iota of truth, but you need to act such a way to come to the conclusion of the matter. So basically, they are looking at all those things that I've mentioned, which also form the basis for the application. But again, one important thing that we need to, which also is the fulcrum of the application, is that does the president have the right to remove her as Justice of the Superior Court or to remove her as the Chief Justice? Okay, if you look at where at the provisions of the Constitution, basically the Article 146, it gave a whole procedure, everything encompassing removal of Superior Court of Justice and then removal of Chief Justice. The article even sort of separated it by a way. So he started with the removal of Superior Justice of the Superior Court before it came back to the Chief Justice. So if you look at it, you have to ascertain whether it's the same thing. And so what it means is that if you are able to remove the head, the tails means nothing. Is that the case? So, I mean, that's what I'm saying, that they will have to go to court. And you even look at it, if we are unable to appreciate it well, then it means that it gives room for another application, another interpretative application. You understand? So basically, we thought we've ended this whole process or whole thing about the removal of Chief Justice, but we might go a long haul with it. We probably might not finish as we think that we have come to the conclusion of it, because another school of thought will look into whether a single application of a bundled application could warrant the removal, or the warrant the what do you call it, the fiat that the president put up to say that, okay, now the Chief Justice is removed, or do we need to go through all the applications because they were bundled together,
right,
and they were given to the committee to look at it? So do we have to wait to make sure that every single petition is well delved into before we come to the conclusion that arrived before? So we have a long way to go with it, that I think.
You touched on my next question, the interpretation or the interpretative nature of it. The fact that the Constitution gives provisions for the removal of Justice of the Superior Court and another provision for the removal of a justice of, the Chief Justice. Shouldn't we be going to the Supreme Court for an interpretation, rather, to make it clear that if the petitions are for the removal of the Chief Justice, then it can also affect her as a member of the Supreme Court bench?
So litigation is law as well as strategy. So you don't get up to go to court because you think you have your right has been accrued. You have to understand the kind of strategy that you have to put together. And I'm feeling the vibe now, how the legal team of the Chief Justice are approaching the matters. This is what I expected long ago, even when the matter started. You know, of course, there were lapses that are now they are correcting it, and it's good. So it's a strategy. It's not about what you feel has to come first or not. There are other things, that other angles that they even come up with, probably we are not aware. But the bottom line is that we want to justify that the Chief Justice was wrongfully removed, and then the whole procedure was now void, and that whole act shouldn't have started in the first place. So that is what the legal team is trying to portray, and that is what they are putting together. And that is what, for us, the legal practitioners, we have to pay attention and listen to what will unfold in the process. But the bottom line is that whether they start with this or they go to another one, it's within their own remit. So they can do whatever they want to do. But I just open the eye that there are other things that we even have to look at it. And all of them give right for application or for an opportunity to appear before the court, for the court to look at all the matters that we feel we need to delve into.
There's these applications being filed expose the loopholes or the gaps in the Constitution, which the Constitutional Review Committee should be looking at.
So you see, I've heard this argument several times, and people believe that, of course, I mean, we've tested our Constitution for a while now, and of course, like a machine, you might even decide to oil it as you operate with it. But I don't think there are too many loopholes for the Constitution as we want to portray. But then the bottom line is that whatever be the case, there are ways of tightening the constitution. So you either make amendment to tighten it, or you go for interpretation for you to get a better view of the constitution. So probably we have not averted our mind to the rationale behind the provision made for within the constitution, that is Article 146. If you look at the history of it, probably you understand why they did that. We have not come to that one. So probably, what was it for? And when you go for interpretation, the judges will make sure they review everything around that to come to the fair decision. So we have to find out what type of constitutions that the 1992 Constitution mirrors. And then what was it intended for? What was the provision intended for? The provision, was it there to make somebody powerful, or was it there just to protect a very good, essential institution of the state? Or it was just to make sure that at the whims and caprice of a president, the president can say that today I cannot work with a chief justice and I can remove the chief justice. And what will be the implications of it? Are we going to experience subsequently any government comes and find another subtle way of dealing with somebody if I feel like I don't like you, or if I feel like you might not champion the agenda of my government? Of course, bear in mind that even though the chief justices are appointed by the government or the president, they are not supposed to be political. They are not supposed to be part of your government. They are supposed to be there for the checks and balances. So I believe we have a long way to go, like I said, and we are able to learn so many things, and then we can make changes to it. So at the end of the day, these cases related to the removal of chief justices that are being decided by both courts, be it High Court, the Supreme Court, will inform the Constitutional Review Committee, also put together by the government, because they are also, it's stirring their understanding of the provisions and also deciding on who they need to consult. So if truly there's a huge gap that needs to be filled by amendment, I think they will take it up. But I believe, notwithstanding that, the courts are able to address those matters independently.
Thank you. Oxford Osei Bunsu is a legal practitioner. Alexander Aban is also on Zoom now. Alex, welcome to the forum. We are talking about the former Chief Justice's new move, filing an application at the High Court, challenging her removal as a Superior Court Justice. We're talking about the options and that the former Chief Justice had, the fact that she could have gone for an interpretation at the Supreme Court, but she decided to go to the High Court rather. What's your reading here?
Thank you very much. Good morning to your cherished listeners. The truth of the matter is that as we speak, if we're dealing with issues of judicial review, as has been filed, it means then that the applicant is challenging the procedure because it does not deal with substantive law. When it comes to this judicial review, it only deals with procedural law. That the procedure that was taken in removing her as Chief Justice is wrong. That is the essence of this application. But in order to determine whether indeed it is wrong or not, we'll have to weigh it against the law as has been promulgated or as has been interpreted by the courts. If you look at Article 11 of our Constitution, you will realize that it tells us the body of laws that we have starting from the Constitution itself until to what we call the customary law, and of course the common law. There are many things in between there. There's statutes, LIs, CIs, constitutional interpretation by the Superior Court and all that. Now, let me first address the issue of gaps. My learned friend who just spoke was talking about that if there are gaps, then we'll have to go and have the Constitution amended or probably have constitutional interpretation. I believe that somewhere in 2004 or 2005, I think 2000, yeah, I may be wrong, but it's between 2004 and 2005. One lawyer, Bright Akwete, took a matter to court for the removal of Justice G.K. Appiah. That is the Ejechum case. In fact, the gaps that exist were clearly identified by the judgment of the Supreme Court. And if you read the judgment of Dateba JSC, you will see that he made a comparison of the processes for the removal of the Chief Justice with the processes for the removal of any other Superior Court justice. And he was very clear in his words that if you look at the processes, there are gaps because the logical sequence itself do not follow very well when it comes to the issue of the removal of the Chief Justice. And that being part of our laws, it means then that by judicial interpretation and pronouncement, those gaps had been taken care of. And so the president should have been guided by the decision in Ejechum versus Attorney General. In all the discussions that we have had, it appears that case is so silent. No mention has been made of that case. But I believe that the case identified the gaps. And so, with the gaps identified and the kind of solution that the Supreme Court preferred in that case, the president should have followed that. Because in the Ejechum case, the Supreme Court said that if you look at the process for the removal of a Superior Court justice, the petition will be taken to the Chief Justice. The Chief Justice will have to make a prima facie determination before a committee will be put together and all that, and all that, and all that, and all that. In the case of the Chief Justice, that layer is not there. But it appears that from the practice as we have seen it in this case, it appears that the president himself, in consultation with the Council of State, were the ones who determined the prima facie case. And then the president went ahead to put together the team or the committee to look into the matter. Unfortunately, this is my view. Even though that gap seems to exist, it appears to me that the framers of the Constitution, in their wisdom, felt that the Council of State itself, looking at the process of their elections and all that, would be composed of men and women who have their own independence of thoughts and would look at things objectively. But I think, from my hindsight, they were wrong. The Council of State has become so partisan that they would not stop at anything to achieve a political end. And that's exactly what we have seen in this, in this removal process. A Ejechum case was sidestepped completely. Nobody even took care of it. took notice of it to apply what the Supreme Court said. Then, Council of State, which would be the stopgap body to objectively look at the petitions, has also become so partisan. And in order that what I'm saying, the allegation I'm making, would have some kind of foundation, I would like all of us to maybe cast our minds back to the elections of the Council of State members that went on. In fact, in the 16 regions, almost every person who won the election had one thing to do or another with the NDC. Some of them were even former constituency executives and all that. And so these were politicians, properly so-called, who found themselves put together as the Council of State. So they had no difficulty in just putting a stamp on it that, look, let us take her away. Because we must also understand it from history. This was a campaign promise to themselves that it would only call for the removal of the Chief Justice, as they put it, so that the judiciary would get some kind of respectability.
Right. We would, Alex.
This application, yes.
We will talk about the politics of it, but in this case, as we have it now, the application that has been filed, should the president or should the case, should this have been taken through the two procedures? One for her removal as Chief Justice, and the other, the removal as a member of the Supreme Court's bench, because the petitions that were filed were seeking her removal as Chief Justice.
Okay, we should not, if I say, play any kind of semantics with this. Because if you read the Ajay case again, it will also say that the Chief Justice is first and foremost a Superior Court justice, just like his or her colleagues, right? You do not wear one hat at one time and look for one thing or one set of rules to be used in removing you, and wear another hat for another set of rules to remove you as Superior Court justice. So for me, that argument looks too cosmetic. If your conduct, I'm not saying she's done anything wrong, but if the processes that went on were to be held to be valid and she has been removed, it would be incongruous to say that, I have been removed as Chief Justice, but I have not been removed as a justice of the Superior Court. And
that's where her argument comes in, that there are two, the Constitution make provisions for the two. They're separate. Chief Justice, the procedure is very different from that of a Superior Court judge.
I disagree. I disagree in the sense that if you're going to make the argument that she is a Superior Court judge, right, and so she must be taken through that process for her removal, would you say that if that was taken first, the petition would have been given to her herself to now determine a prima facie case against Torkonoo as Justice of the Superior Court? Because she would have been the Chief Justice to receive that petition. So we must not make this cosmetic argument, because it has to do with a person and his conduct or her conduct. And so for me, if your conduct as Chief Justice or as Superior Court Justice, no matter what, it fuses into the same one and individual person. And so if you are genuinely removed as Chief Justice, it presupposes then that you have also been removed as a Superior Court of as a Justice of the Superior Court. So that argument looks too academic for me. But I hold my view that that whole process is a masquerade and an injustice to her. But this new argument that, I was only removed as Chief Justice, but I was not removed as Justice of the Superior Court, I beg to differ with her.
But in the petition, and the response from the committee, what the committee found, 1.9 says, in the opinion of the committee, the travel expenses which the Chief Justice heaved on the judicial service when she traveled on holidays in September 2023, first to Tanzania with her husband and second to the US with her daughter, together with the payment of her per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. This is her playing her role as Chief Justice, for which reason they found her to have misbehaved. Thank you, Lawyer Aban. I'll come in studio now. Kwame Jantuah, Lawyer Kwame Jantuah is in studio. Thank you so much for joining us, Lawyer Kwame Jantuah. And also a member.
First time of meeting you.
Right. Good to see you. So I guess I am new on the show.
Yes.
Mr. Jantuah, good morning. How are you?
Mr. Aban? Where are you? You're not in the village, oh. You're sealing
I'm in the
village.
You have to come here one day.
But you have to come in studio. You haven't been in studio for a while.
Next week I'll come and see you. Next week I'll come.
Okay.
Take my word for it.
Okay.
Lawuratu Musah-Saaka is a member of the NPP communications team. Welcome, Lawuratu. So let me continue the conversation from where Alex left off with Kwame Jantuah. The former Chief Justice says is challenging her removal as a member of the Supreme Court's bench. Lawyer Aban doesn't agree with the arguments that she's making. If she's been removed as Chief Justice, then as a member of the bench, she's also been removed.
Is that what Lawyer Aban is saying?
Yes, that's the argument he's making.
That's the argument he was making. I got it different. Well, the first thing I will say, good morning to our listeners and good morning to our Facebook panelists. You're part and parcel of what we do here. Let me ask a question. Please, what's your name?
Gemma.
Gemma, how long have you worked in Asaase for?
For 5 years.
5 years. When you came, what did you start as? And I'm just asking you because I want to give an example. What did you start as?
As a journalist.
As a journalist. And you've risen through the ranks. Let's say you rise through the ranks and they make you deputy CEO of Asaase. Then something happens and the owners of Asaase question you, have an inquiry, sit and say, Gemma, unfortunately, because of A, B, C, D, E, and based on the facts of the case, we cannot continue to employ you. Do you then argue with them that, okay, take me back to be a journalist? Do you?
The point is,
Chief Justice, they've found, what do you call it, against you. Take it and let's move on.
The difference here is that the example you give may not necessarily apply in the Chief Justice case because her provisions for her removal is in the Constitution. It's not as though management can just sit somewhere and then take. Are
you saying there are no provisions for removal in Asaase?
It is not the 1992 Constitution.
Every business has some kind of a constitution which they follow. Public service, when you work in parastatals, they have processes in which you can either hire or fire. But you see, the one thing I've always said, and this is where my good friend Araba made a mistake. My friend, so I tend to call her by first name, but Chief Justice, former Chief Justice. This is where she made a mistake for me. Article 146(11), what does that say? Article 146(11).
The president may at any time revoke a suspension under this article.
Read it slowly. Read it slowly.
The president may at any time.
That is the operative word in that particular clause. Continue, my dear.
At any time, remove a suspension under this article. Revoke a suspension under this article.
The president may at any time revoke a suspension under this article. He has the sole discretion to do that. He might decide that he would get advice from whoever to be able to revoke, but he has the sole discretion. So when I heard the former Chief Justice do media, this thing, I said to myself, first of all, that is your evidence. Why put your evidence out there? What are you trying to court? You're trying to court public sympathy. Let your evidence be watertight, and when you meet the committee, you sit with them and then you argue your case.
She was raising concerns about the conduct of the committee.
Who was going to listen to who was going to question her? She raised it. Did she not go to the committee? Then she should have decided she would not go to the committee. But she went to the committee. And for me, that evidence that you had, I didn't think it was for public consumption. I didn't think it was for public consumption. And I really feel that this thing has gone full circle. She's still at the ECOWAS court, isn't she? Have they come up with any suggestion? Have they sat on the case at all? So I tried to find within my mind, really, what is she trying to say? What is she trying to prove? Do you know that?
You don't think she has a strong argument?
Have they not, has the verdict not come out?
The application?
So, yes,
I'm talking about the review application that she's filed.
And I'm saying, she's going back to the Supreme Court.
The High Court.
The High Court. She's going back to the High Court.
Yes.
Okay. Let's see what happens. But I think she should let sleeping dogs lie. I believe if she went 14611, there could be some negotiations. Look, in everything you do, there are negotiations. And for me, the most important thing there was her entitlements. That if for nothing at all, if she wanted to bring something back or discuss something, it was based on the entitlements. And I'm sure the person who nominated, and remember, the Chief Justice is not put in place by a group of judges or a group of people from the judiciary or a committee set up like you have in the UK. It is the sole responsibility of who? The president, isn't it? And if something has been found to be what's the word I'm looking for? If something has been found to go against her, the processes in the Constitution that come to the fact that, you know, the president should use those processes to get her case heard. Would we say the president, there was anything ultra-vires in the way he handled it? Did he not go through all the processes according to what was in the Constitution? Can we fault the president for going through those processes? Let's put the politics aside. The politics mars a lot of the things. And you see, that is one thing about this country. We put everything under politics. And I think we should get to a stage where we are able to differentiate. Because look, the judiciary is an arm of government, isn't it? 3 arms of government: legislature, executive, judiciary. It's an arm of government. And in fact, it's a very technical arm of government. If you take the two, legislature and executive, the most technical of all is the judiciary. And so for me, that clause in our constitution, which indicates that the president should nominate, we should look at that again. We should look at that clause again, because from time immemorial, it's created challenges for us. And I hope the Constitutional Review Committee looked at that particular clause where it says the president should. Because they're talking about separation of powers. So what has the executive got to do with nominating a chief justice? If we are practicing real separation of powers.
But there's also checks and balances.
Which are the checks and balances? Which are?
The president nominating the chief justice going to parliament to be vetted, and the president swearing him or her into office. I mean, also to ensure that even though there is separation of powers, they are also checked by each other.
Do you know the way the British get their chief justices?
Tell us.
They have a committee of judges, independent people, and executives. I think it's the Lord Chancellor who sits on that particular committee. And they choose, you apply, you choose, they choose, and then it is recommended to the Prime Minister, and the Prime Minister ratifies. They go. Maybe we should have that kind of system here. And that is where you have real separation of powers. And anyway, even if we go down that route, yeah, they can still go for vetting, can't they? And their own people can vet them, can't they? For people to see, okay, these 5 people have put an application in to be Chief Justice. So this is the vetting. Show it on TV for everybody to assess those who are being, It doesn't necessarily have to be Parliament to do it, but there could be parliamentarians part and parcel of that committee that vets them. Maybe that is where the challenge is. Maybe that's where the faux pas is, and we should look at it and try and change it so that the president doesn't have that mandate to always bring in a chief justice of his choice. Because definitely politics will come in, and politics has come in. Politics has definitely come in.
We heard the Attorney General at the Bar Conference say that there is an intimate relationship between politics and the law. So if that is the case, then it's playing out here. There isn't...
What is the intimate relationship?
What's the problem here?
What is the intimate relationship? Ideally, if we can, an Attorney General that has been put in place is an Attorney General and should stick to his work as an Attorney General. Yes, when you look at Attorney Generals around the world, how many times do you hear them talk? Do you know the Attorney General of the UK? Do you know the Attorney General of America? And even if you do you hear them speak? Do you hear them speak? Look, I believe that with the Attorney General and what he said at the Bar Council, we need to be able to have some what's the word? We need to be able to work together. Even if the Attorney General felt the way he felt at a Bar Council, how do we work together? That was the question I wanted to hear from the Attorney General. How do we work together as a team? The Bar Council is an important institution where lawyers are concerned. The Attorney General is an important institution. He's part and parcel of the bar. Is he not?
He's the leader of the bar.
Yeah, he's the leader of the bar. So if for anything at all, yes, certain things went on that you weren't happy with, let's see how we work together. That was the line I thought he should have taken, because it made it sound as if it was the bar against the executive. And I say the executive, the fact that he is the president's lawyer in terms of governance. It seemed there was some infraction there. But I was looking for unity. I was looking for a situation where, yes, this is what has happened, but we need to work together as a team. And hopefully, some of the things I've outlined, we will try as much as possible for it not to happen again. But yes, on the other side, the bar too, maybe there were certain things that people expected them to talk about and they said nothing about. So people were pointing fingers. Because in the past, I've seen the Bar Council to be strong, very, very strong. Strong on issues. Be it NPP, NDC, they've been strong on issues. And maybe some people will feel, okay, the way the Attorney General felt, that on certain issues, you were quiet. We expected you to talk, we were quiet. But maybe they also had their reasons for being quiet. But because it's a governance issue, all the three arms of governance should be able to work together. And those three arms of government, they provide a check, for each other. The legislature check the executive can check the judiciary, and vice versa. I want a situation where we can work together because we have a country to govern. The challenges of this country are plenty, and we cannot allow the different arms of government to be at loggerheads with each other because they have a responsibility. It's the people of Ghana who have put them there, and they have a responsibility. And when they don't agree on certain things, they should try as much as possible to do what? To talk it through and agree and move on. I think, my dear former Chief Justice, should let sleeping dogs lie. Let's end the case, and then let's move on.
Some have said that this will help deepen our democracy and make the provisions in the Constitution clear for future references. Is that not a good enough reason for her to still fight on?
The Constitution is a living document. For me, I think 30 years of a Constitution we need to review, which the President has put in place, because things have changed. When this Constitution was done in 1992, was there AI? The kind of smartphones we have, was it there? The kind of things that are happening within our own country, were they there? So it's a living document, and in fact, there should be probably some clause in the Constitution that allows us to review after a certain time, because things have changed.
Right.
I think that would help.
Lawuratu, I'll come to you. One will ask why she's going through all the former Chief Justice is going through all these processes, legal processes, to what end?
So good morning once again. Good morning. To our listeners and viewers, and to Mr. Jantuah.
Good morning.
The most loved guest on this show.
Really? Just hear the butter me.
The Facebook crew will prove that. I mean, Gemma, this is purely a case of a promise made, a promise delivered by the current administration.
How?
It's purely this can even be compared in a way to the case of Shylock and Antonio in Merchant of Venice. Pound of flesh. But unfortunately, our president took his pound of flesh and forgot that blood was spilled. I mean, in that context. And that's where we find ourselves as a country now. Look, one thing we need to make clear is judicial independence is not negotiable. It's the shield for the citizen. I'm not a lawyer, but listening to lawyers from the beginning of this, even before elections, the utterances that members of the current administration, including the president himself, made. I mean, this wasn't coming. The first time I heard they picking this up, I knew, unfortunately, we have so much executive power vested in the president that if he wants to take his pound of flesh, he'll take it, because all the people that will constitute the committee, who appoints them? It's the president. But was it right to do so? I think that with all the conversations going on, the president should have just let it be. Yes, you had issues, but you promised a reset. It's resetting the judiciary, as he said. But it means jeopardizing the independence of the judiciary.
But
look, Gemma,
ordinary Ghanaians who petitioned the president, they made their case. The president went through the processes. How do you blame the president for removing the Chief Justice?
We have three arms of government. I mean, with all due respect to fellow brothers and sisters, if I may, that are disabled. But for those of us who are able in that context, you get so used to using two hands that if something happens to one, you are virtually disabled until that other hand or that other leg becomes fit for purpose. There are three arms of government. Two are obviously partisan. It takes a party to bring a government in power. It takes parties to constitute our parliament explicitly. But for the judiciary, that's the safe haven for every citizen. Even with all the things that the current administration said about the judiciary, anytime they lost a case, but they still took cases to the judiciary. It may not be a perfect institution, but that is our safe haven as citizens. So if you have a president coming to power and set such a problematic precedent, then we have a problem.
Do you think there's a problem in here? The president, the government continues to defend this, saying that they went through the processes. This is what the Constitution says, and they did not flout any provision of the Constitution, to be fair to the government and the president.
Gemma, just a point of order. Who put in the application? Was it the party or was it a
ordinary citizens?
Ordinary citizen.
Mr. Jantuah, let's just be clear on some of these things.
Okay.
At the end of the day, how many of those petitions were even considered in the decision of the committee? One. That one from the CJ and her lawyers' submission, they still even have issues with those things. But I think the CJ is within her rights to seek this review, and her resolve to fight this is also admirable. I think she basically refuses to be bullied by anybody, no matter the outcome of this. Because look, I'm not a lawyer, but Article 146 that is being used stipulates different procedures for removing a justice of the Superior Court or a chairman, or should I say chairperson of a regional tribunal. It's explicit, unless they want to read the law. And Mr. Jantuah made you read Article 146(11). But when you read 10A and 10B, it speaks to it. They are the ones who tell us that you don't read the Constitution in isolation. That's what they tell us as legal people, So we, the lay men and women, if I may, have been following it. If this was really right and the best thing to do, I don't think lawyers would be splitting heads, judges would be splitting heads. I remember when it came out, it was announced that the Chief Justice had been removed. I heard lawyers who argued that she can still stay as a Chief Justice because of what Article 146 says. But in all this, I think that the energy the government put in removing this Chief Justice, they had put that energy at least in solving Galamsey. All those issues that we have, won't be here talking about these issues. But some of these things, we just have to let them be.
I'll come back to you.
Because the judiciary is our safe haven as citizens.
I'll come back to you for you to answer the question, to what end. Kwame Jantuah on Facebook says, it is my prayer that the court should grant the certiorari application by the former Chief Justice. The president erred in law and forced her out of office. I'm asking the question to what end, because this is not the first application she's filed regarding this whole situation of her removal. She's been to our courts in Ghana, she's gone to the ECOWAS courts. Now she's back in courts at the High Court seeking a judicial review. To what end? Mr. Jantuah says, let sleeping dogs lie. Just look for your benefits and let's continue with our lives.
And how is she going to look for her benefits if she doesn't seek for a review? Because whatever document that's said that she's been removed, you set out to remove her as a Chief Justice. How did it happen that the process is set? When did they take that process? I mean, we can argue HR, we can argue procedure, but the law or the judiciary is just not like any ordinary institution. Right? So, and the Article 146 that they are using clearly stipulates 2 separate procedures. So, where do they reconcile both? Yes, you removed it. You removed as a Chief Justice. Did you remove her? Was the petition to remove her as a Justice of the Superior Court? Those are the questions the government should. And you see, when things are shrouded in secrecy, when there's lack of transparency, you bring out all these speculations. Right?
When we posted this news story on Facebook, there was a comment that popped up. Yaira said, so how can you misbehave and be incompetent as a Chief Justice and still think you are deemed fit as a competent judge at the Superior Court? That seems to be the argument from lawyer Kwame Jantuah and lawyer Aban when we spoke to them.
What's the definition of misbehavior? It's one of the things the lawyers are agreeing about. The amendment of that article at least should define what misbehavior is. What's misbehavior? Were those things that she's accused of, were they not part of her conditions of service? Were they not? Or now anybody can get up. I can get up and say in the studio, the way Mr. Jantuah is sitting, I'm not happy. So I'm petitioning the management of Asaase not to let Mr. Jantuah come to. So anybody can just get up and define their own form of misbehavior and you suffer for it. Is that what we are saying? Is that what we are saying?
I think that's what some lawyers are also saying, that we should have
We are
had
not
a
a lawyer. So I'm asking those
Gemma,
questions.
what she
So
was
to
accused of,
state-
can you read it? What she was accused of?
So per the letter that the presidency actually wrote to her announcing her dismissal, they gave the reasons why they were removing her based on the recommendations by the committee. That's 1.9. In the opinion of the committee, the travel expenses which the Chief Justice heaped on the judicial service when she traveled on holidays in September 2023, first to Tanzania and with her husband, and second to the US with her daughter, together with the payment of her per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. 3.4 says the committee states without fear or favor that the Chief Justice unjustifiably breached the provisions in Article 296A and B of the Constitution in the way and manner that she transferred Mr. Baden. Her conduct amounted to misbehavior. 6.7, the committee is of the view that the conduct of the respondents are squarely in the category of conduct described as stated misbehavior under Article 146 Clause 1 of the Constitution. 7.5 says the committee is of the opinion that the action and conduct of the Chief Justice falls within the meaning and categories of stated misbehavior as provided under Article 146 Clause 1 of the Constitution. 9.5, however, the Chief Justice, Chief Justice, cannot lay claim to ignorance of the nomination process and procedure, notwithstanding the fact that the process and procedure are not spelled out in the Constitution but case law. The appointment of the Chief Justice herself as a Justice of the Supreme Court went through the very process and procedure set out in the Ghana Bar Association case. Therefore, to seek wittingly to outwit this known process and procedure for appointing Supreme Court justices amounts to misbehavior in the eyes of the committee, and the committee finds it as such.
Was she given the chance to defend herself?
She was at the committee.
Exactly. And what did she say in defending those accusations? Has she denied any of those things that were said in the public case? So what are we talking about? Did she pay the per diems they're talking about? Has she said, yes, I did? No, I didn't.
But what we understand is that it's a practice that has been there for a very long time. She's not the first person
It
to
could be a practice that is there, but it could be a wrong practice. The fact that you
So
have
why
been...
should she be
wait,
punished
wait,
for
wait,
it?
wait. The fact look, in the UK, when you take cocaine and you take drugs through the airport, you think they don't know? They know. Quite a number of people have done it. But one day Kwame Jantuah will do it. 1, 2, 3. It's Kwame Jantuah they'll catch. It's unfortunate.
But
It's unfortunate.
Mr.
How fair is
Mr.
that?
Jantuah.
I mean, if
Mr.
that is the how they operate, and a former chief justice or a chief justice who was in power or in office enjoyed it, and that has been the practice over time.
The practice could be a wrong practice.
But
So why should she be
Gemma,
the person facing the law for it?
Gemma,
Why not?
Let's
Why not?
even, Mr. Jantuah, let's
Lauren?
even assume.
But you see, just a minute, Loretta.
Okay.
It is a private individual who put this application in. Period. It's not government.
Gemma.
That is what we tend not to want to bring to the fore. It wasn't government who put it in. And when the private person put it in, there are processes in the constitution that the president and whoever is concerned should follow. That has been followed.
Christopher Abe on Facebook says the outgone CJ must let sleeping dogs lie. We all need to pray for time. The CJ or the former CJ has been treated very badly, but I believe she will let it be. Baba Chairman says that did I hear Mr. Jantuah say we should remove politics of the CJ removal? That is very impossible because the president in opposition told everybody that the judiciary would be purged should the NDC win power.
Is that right?
Mr. Jantuah cannot be
right?
picking and choosing in reading the
No,
constitution.
is that
That's why I
right?
said
Is that right?
You see why I said he's the most loved guest
Listen.
on the show?
Is that right? Is that right?
Is what's right?
That the president in opposition should have said what he said. It's politics. That's the kind of thing I'm saying. It shouldn't be part and parcel of it.
Then the president should have let it be.
How?
How?
After all the utterances he made. Look, Gemma, let's put this in context. You remember the example Mr. Jantuah gave about you starting as a journalist? Look, every institution, and no mean the public service, has procedures for funds. And the funds that I'm even talking about, for example, did the CJ take them herself? We sit in this country and we see Public Accounts Committee call people. We hear people refunding funds that were allocated to them that were not
Wrongly.
used. Sometimes it's not even that they use the funds for something personal. It's just misapplication of funds, and they have to refund and all those things. So how does the CJ also have to suffer for this, should I say, accounting procedure when someone is in charge to do that? Okay, audit flagged it. They paid back, and that wasn't the first time. So is it about changing the processes or about punishing the CJ for a systemic problem?
If it's a systemic problem, she could also have been the one to change that problem, rather
She
than
didn't change it.
benefit from that
Well,
problem.
she didn't change it. That she have to be punished for that.
How then do
When
we
there are processes.
ensure some accountability on the part of the judiciary? Because it is an arm of government, it's a technical arm of government, as Mr. Jantuah put it, a very important one, but it's also not too big for accountability.
Why do we have internal audit? Why do we have external audit? It's to pick some of these infractions. When auditors run an audit and they pick issues, they first discuss with the management. Just as the Public Accounts Committee does. Why do they call people to come and answer for infractions? To be sure that there was no clear motive to do those things. These are conditions that are stipulated. You'll be amazed at some of the conditions. Probably then we should do a review of the conditions of the Speaker of Parliament, the conditions of the President himself. So some of these things, they are systemic issues that we need to deal with it. But just because you made a promise to come and remove a CJ, doesn't mean that you obviously now the independence of the judiciary, the safe haven for we ordinary citizens, has been compromised, whether we like it or not.
How?
It has.
I'm asking how, because
But if a CJ
the
can
CJ
be
is
removed
gone,
just
there's
like
also
that,
an acting
then no
CJ.
judge is safe. You think any judge is safe?
The Constitution
Anybody
made
can just
provisions
get up
for
and write a
that.
petition. It will be sent to. There are processes for removing judges too. Anybody can just get up because they went to court. There was an issue. There was a case that they didn't win. They make a case out of it just to remove the judge or whoever. We need to be careful. That's the safe haven. That's the only arm of government that you can clearly say that it's not explicitly partisan. When you go to parliament, you have minority and minorities. Now we even have just independents. There are only two clear parties, the NPP and the NDC. It's parties that bring the executive into power. Yes, we may have some judges that are alleged to have leanings or biases, but have we ever, has any judge at the various levels ever been appointed because they are affiliated to party A or party B? So psychologically, that's the only neutral arm of government we have, and we compromise it like this just because promises were made during campaign. The same court that was loaded, that was too crowded, suddenly has space for 7 people. Come on. Some of these things, we just need to be clear about it. Our judiciary has been compromised, unfortunately. And I think that will also be in the interest of the Ghana Bar Association to take the CJ issue up, because it equally affects them.
How are they supposed to do that? They spoke about, they passed a resolution asking the president to reconsider his decision to suspend. They have been speaking against it, that there is no CI that stipulates what a misbehavior or misbehavior is.
They might as well be interested in whatever review is going on, because this is just not right, no matter how you look at it.
So, Koja Free says, Mr. Jantuah will give time some time. Baba Chairman again says, Mr. Jantuah must stop making mockery of the 1992 Constitution by being selective in the way he uses and interprets it.
How have I been selective?
Ask Mr. Jantuah whether he critiqued the president in opposition for making those reckless comments. He didn't find it necessary to criticize the president.
Am I not saying it now? What did I say now, Gemma?
Yeah. Yes.
What did I say now?
Yes, he just mentioned it. Sylvester Watson says, Mr. Jantuah will never cease to amaze me. His argument is simply one of intellectual dishonesty. Abdul Basit Mahama says there's so much we don't know about the committee's work. They are leaking portions they want us to know. Government should simply publish transcripts of the committee's proceedings. This is something that a lot of lawyers have been pushing for. We need to get
we don't know whether there's transparency or there's no transparency. Let them publish it. Let us all read it and let us all make our own decisions about it. So far as I'm concerned, there was no ultra virus in the president's conduct and how he handled the thing. Okay, my dear sister is saying because of the comments he made when he was in opposition, so he had some mens rea there.
Motive.
They had some mens rea, some intention there to remove the Chief Justice. So are you telling me if it so happened that she went to the committee and she was found innocent, the president won't work with her? Is that what we're saying? Because of the comments he made in opposition? What president hasn't said made political?
Do you think that that would have been a possibility when this whole process started in April, that there was a possibility that she will go through this and then be exonerated and come back as CJ?
I'm saying that if it so happened, I'm not saying
but it didn't happen.
I said if it so happened that was the case, would the president listen? The point I'm making is that if it did happen that she was exonerated, can the president say he won't work with her? Can he say he won't work with her?
It didn't happen, Mr. John.
The fact that you see, we
so let me go to the phone line. We have the lawyer.
We chop and change all the time.
We have the lawyer for the former Chief Justice Ayikotu. He's on the line to us.
Okay.
Welcome to the forum, Mr. Ayikotu. Can you hear me?
Yeah, I can hear you. Thank you.
Thank you. So we heard that Okay, so let's try to rework the line. I think it's better now. So what's the strategy of the former Chief Justice in going to seek or filing an application at the High Court to challenge her removal as the judge at the Supreme Court?
Well, okay, thank you. I think, I don't know. I haven't listened into the program, so I don't know who and who are there. But if you have some lawyers around, I think they do know that
Gemma, put it.
what happened was an administrative tribunal to which this matter was referred. Article 146 allows the or invests power in the president, having received a petition for removal and having established a prima facie case with the Council of State, who set up a committee of inquiry, go into this matter to confirm as it were the prima facie determination that they had made. And so that committee is an administrative body. Under Article 23, they were acting not as judges, because as you know, there were only 2 judges, the rest were all laymen. So being administrative bodies and administrative officials, their actions can always be subject to judicial review, and the High Court has jurisdiction to deal with such matters. That is why the Chief Justice chose to go to the High Court and not necessarily to the Supreme Court. I hear some people talking about Supreme Court. Supreme Court is for interpretation, and interpretation comes in only when you are not sure of the words used. In other words, if the constitutional provisions are ambiguous, they are subject to more or 2 or more interpretations, then you want to go to the Supreme Court, which has the sole authority to clarify what they think that provision means. Otherwise, as was stated many years ago in the country, so long as the law, the Constitution is also a law of this land, it can be applied as when they are appropriate. You don't need every time to go to Supreme Court. Again, in the event that a High Court judge finds that the what is being called upon to deal with amounts to an interpretation, he has a right to refer the matter to the Supreme Court itself. So, to me, what has been done is proper to see whether they acted in accordance with law. After all, we have the substantive justice and we also have procedural. So if when somebody says, I have not been given a hearing, we are not going to the substance. All he wants to establish is that you took a decision against me without necessarily giving me a hearing. That is more procedural, not necessarily a substantive matter. Now, which he has continued to say everywhere, that she has never been shown what the so-called prima facie determination was all about. Look, if we talk of prima facie, you are saying on the face of it, we find that you have committed some wrongs. Now we set up the committee. What do you think the committee would do? It is for the committee to confirm whether or not what they heard at first blush is correct, or to deny, to say that no, these things were well explained during the hearing, and therefore they no longer form any grounds for which anybody can say that this person ought to be removed. So when the committee is set up, it is to act in accordance with law. It should not be on its own. And the woman, the Chief Justice said, show me the prima facie determination that you allegedly made, in which areas, so that I prepare to come and give my testimony. They refuse. give me a copy of the petition. He refused. The petition which was sent to the Chief Justice was also not given to her.
But the
now,
Mr. Iko Otu, please. But the former Chief Justice appeared before the committee to give her side of the story, even though she was not giving a copy of the prima facie case that the Council of State established against her.
What is wrong with that?
I'm just asking for clarity.
No, but that is what I said. That while she was there, she kept complaining. And they kept doing whatever they wanted to do. So at the end of the process, because they kept saying that it is in camera, all it means is that it is only at the end of the process that you can challenge the things in the courts. Do you understand? If she is saying that the grounds, for example, that she might have misappropriated government funds, is not true. Because she's not a spending officer, and that the spending officer, who is the judicial secretary, when the query was raised, explained everything, and the auditors became satisfied. For which reason the auditors did not capture that particular expenditure in their final management report. How then do you turn around to use it against the person that is still involved in having done something wrong? Do you appreciate the point I'm making? It was not a case that somebody has been charged with causing unlawful damage, but this is a case of audit. And in audit, there are steps for doing it. You don't make audit observations and get away with it, but you ask the person being audited to give you an explanation. So once the person gives you an explanation and you are satisfied with it, that ends the matter. And I'm saying that is what happened in this case. The query was raised, the explanation was given, and the final management letter came, and that matter was dropped. How do you turn around to use it? And these were all tendered, and so they were before the committee. Why didn't the committee even comment on those things? I went about saying what they are saying. And you think that if somebody is saying that we have sufficient evidence before them, we decided not to look at, and therefore we have come to the High Court. Is there anything wrong with that? Do you appreciate the point I'm making?
Yes.
And then, for example, that she had transferred somebody, and that transfer is a mistake, stated misbehavior. Where? Have you seen such a thing happen before? In your small organization, don't you make changes? I used to be there. It was is it Dr. something who was doing this program? Today I'm called and I find that someone else who is doing the program. We make changes all the time. So if somebody has been transferred, how can this be a ground to remove a whole head of a judiciary because she has transferred somebody? Or that Kwame went to say she should be removed for having made recommendation to the Supreme Court, and the president and the same council of state said there was nothing wrong with what the person has done. That amount to res judicata? How did they turn around to use it again against the same person? So you set up a committee to go and do a matter, and then one of the committee members sees it as a strike. That in the morning, right, that the strike is over, the battle is done. Is this person really somebody who is truthful to his oath, that he went there to work in accordance with the evidence before them? So please, to me, allow the Chief Justice to go to court to challenge whatever has happened, and then let's see what the outcome would be. After all, in Riakuto, the Supreme Court refused to say that the fundamental human rights of the detainees had in fact been breached. But today, we are praising Dr. Jantuah for having had the boldness to go to court to challenge it, and rather condemning the judges as tumultuous souls. So let us allow the process to go on and see what comes out at the end of the day. If the High Court judge before whom the case goes believes that these are matters that involve interpretation, he has every right to refer it to the Supreme Court or whatever interpretation. And finally, let me say that there are people who go about saying that the Chief Justice has so many cases in court, and that is involving in a forum shopping. That is not true. In a constitutional interpretation, you don't need yourself to go to court. Any Ghanaian citizen can go to court. In the famous case of Adjechum, it was not Akwa who went to court to complain. It was somebody called Adjechum who said that the process for his removal is fraud. And in this same case, there's only one case in which the Chief Justice was involved. All the rest were not started by the Chief Justice. Individuals had gone to court. They should stop saying that she has been going about filing cases in the Supreme Court. She has only one case at the Supreme Court, and they are not even giving a hearing. They have never given a date for hearing, but they always turn around to say that there are cases pending. If they want to be true to themselves, they should set dates and let's hear those important constitutional matters. Let them rule on them once and for all.
Mr. Ikotu, the former Chief Justices also are the ECOWAS courts. Is that not the case?
Yes, that is true. Where she is, I'm saying that nobody runs away from that. But if Ghanaian citizens have decided to go to the Supreme Court, you don't put it around their neck and say that she has got 4 or 5 cases in the Supreme Court. It is not true. Right. She has only one case at the Supreme Court. Even the case is started, the first judicial review application, they never gave her a date until the Attorney General said he had a preliminary objection. And then when he filed his motion, that was quickly set down for hearing. On matter, no date has been given. And then they proceeded in saying that the court has no jurisdiction. How can the High Court say it has no jurisdiction over an administrative body? If that is the law they want to write, let them write it for the day 2025. Some years back, looking back, people will ask them whether they really did justice or decided to do their own thing.
But do you have a date for this new application you filed at the High Court?
Do I?
Have you been given a date? I mean, the application that the former CJ has been given.
It takes a little while. You see, you have to file your process, then the other side will file their process, and then when you receive those things, you file your statement of case, then you file a statement of case, and then a date is fixed for hearing. So that this one has just started. I'm saying that in that one, when we had even filed our processes and waiting for a date, they never gave us a date until the Attorney General said he had a preliminary objection, and this motion was quickly fixed for hearing.
Thank you very much. Nii Kpakpo is lawyer for the former Chief Justice Gertrude Torkonoo. I understand lawyer Oxford is still on Zoom. Let me go to him for his final comments on this, and then we'll try and wrap it up in the studio.
All right. Thank you. Yeah. So I think let me say hello to my brother, Lawyer Jantuah. So my last comments before I leave the line are these comments that I need to. Once the lawyer for the Chief Justice has spoken, that is good enough. But I would say that this current application has a strong basis that has a strong basis. And one thing that we have to understand here is that, like the lawyer for the CJ mentioned, you understand, lawyers are not judges. So you only bring matters to the attention of the judge to make orders or to give relief. So we have to, whatever be the case, once there's a contention, you have to be to the court. So basically that's what's supposed to be. Here is the case that we are contemplating whether the separation between the provisions made in the article. But then what this specific application sought to do is to challenge the warrant issued by the president, just to say that the president has no right to remove the Chief Justice as a justice of the Superior Court. That is basically what the application is doing. We are not saying that the president doesn't have the right to remove the Chief Justice. That is the conversation for another day or what probably the lawyers will want to do again, just to see whether the procedure for the removal, as it were, by the committee were pervasive. But then this specific, I want to bring to the attention of the listeners that this specific application is to say that the president cannot remove the Chief Justice as a Justice of the Superior Court, because if you check the warrant, it stated it. In fact, it started by saying that the provision in Article 14 says it's for the removal of Justice of the Superior Court, before it came down to say that made reference to all the provisions and the work they have done, and then stated specifically that now the president remove Justice Torkonoo as a Chief Justice and the Justice of the Superior Court. So that is what the application is for, and that is what I want us to understand. In any case, where the previous lawyer mentioned that the gaps have been settled by the Ajetum case, which I don't entirely agree, because Ajetum case, I stand to be corrected, it didn't state the difference between the procedure for removal, whether or not if you remove the Chief Justice as a justice, the Chief Justice, automatically the person is removed as a Justice of Superior Court. So basically, even if we get an opportunity for interpretation, these are some of the interpretative, issues that the Supreme Court will probably deal with. So here, we also have to understand that Ajetum case didn't, address that gap. So there's opportunity for the lawyers of the Chief Justice to also kind of seek for redress in terms of that gap. And then again, bear in mind, the reason why the argument for the application is sound for me is because remember that even though the position or status of Chief Justice is provided for by the Constitution, it is administrative role. So if you remember, we have had recourse to believe that there were judges who were senior than most of the Chief Justice appointed, but they were bypassed. But once they were bypassed, it didn't, disqualify them, or probably didn't lose their status as Justices of the Superior Court. So it gives room for the interpretation, gives room for the education, because we've had several judges who believe that some believe that they were embittered for the fact that they were due for Chief Justice, but were bypassed. So if we are trying to distinguish the administrative role from the actual status as a Chief Justice of Superior Court, then there's the need for any application to come before the High Court for the judicial review, and there's the need for any other applications before the Superior Court for interpretation. So basically, that is my basis for believing that the application now is sound, and then they also have other many opportunities if they want to continue with the matter. Nobody is saying that she has not been removed as Chief Justice, of course, but the application now states that no, the president has no right per the Constitution. If they does want to remove her as a Justice of the Superior Court, the Constitution provides for a procedure separate for the removal of the Chief Justice, even though some of the procedure are comparable or some of the procedure are supposed to be similar. Thank you.
Thank you so much. Lawyer Oxford Osei Bunsu joined us via Zoom. Let me take your final comments and then wrap it up, especially when we heard from the lawyer of the former Chief Justice, and he reiterating what she went through at the committee. Lawyer Jantuah.
Well, it's her right to go to court to seek a judicial review. Let's see what comes out of that. And I hope once the judicial review is brought out, if it's something that goes against what she is looking for, we don't now come and use it as another yardstick to keep discussing. If it goes in her favor, then I think it is up to government to publish the transcripts of the committee meeting, the committee hearings, so that we can all see the pitfalls in what happened and the positives in it. But I'll end up by saying one good thing about this entire thing is that it's going to give law students a good sense of practice in terms of studying the discipline of law, which I say everybody should study law because it's a discipline that helps
He's speaking
people.
to me.
Yes, yes. I keep telling you, go and study law. It's a good practice. You see, the thing is that in every part of our life, we need the law. Every little bit of our life, we need the law. And since 1960, or since we gained independence, we only have about 9,000 plus lawyers in this country. And the specializations in the different areas of law have now expanded with new things coming. So I think everybody should consider. And I like what government is doing in terms of, declassifying, the law school and making it easier for everybody to. It's a good training. So let's see what comes out of it.
Right, Lawuratu.
Yes. Listening to Honorable Ayukwe too, what's there to add anymore? See now, he's explained how she treated and the systemic issue we're talking about has been laid bare. But I still think that in all this, the Ghana Bar Association should show interest in this review because our judiciary, which is the safe haven for us all citizens, it's in the balance.
Still listening to Asaase 99.5 in Accra, Asaase 98.5 in Kumasi, Asaase 100.3 in Cape Coast, and Asaase 99.7 in Tamale. This is The Forum. My name is Gemma Appiah. It's here again, the 14th Ghana Economic Forum, Ghana's most influential platform for economic dialogue and policy action. Join us on Tuesday, the 28th of October 2025 at the Kempinski Hotel, Gold Coast City, Accra, as over 300 leaders from government, business, diplomacy and development gather under the theme Currency Stability, a Reset for Sustainable Economic Growth. This year's forum will feature powerful plenary sessions on strengthening the economy and finance, unlocking energy and renewable solutions, and transforming agriculture and its value chains. Expect bold conversations, actionable strategies, and high-level networking that will shape Ghana's industrial future. The Ghana Economic Forum 2025, powered by the Business and Financial Times with support from valued partners and sponsors: Bank of Ghana, Fidelity Bank, KPMG Ghana, Arthur Energy Advisors, Olam Agri, and the Bank Hospital, Asaase Radio, TV3, Joy FM, Metro TV, City FM, Channel 1 TV, Happy FM. Don't miss out on this defining national conversation. For partnership and sponsorship, call 0244 689 521, 0244 689 521, or 0209 457 427, 0209 457 427, or visit GhanaEconomicForum.com. The 14th Ghana Economic Forum, where Ghana's future takes shape. So we just finished the conversation on the Chief Justice, the former Chief Justice, and Nii Kpakpo Samoa Addo. Nii Kpakpo Samoa Addo just walked in, so I'm just going to give you.
You are the new host, so you relax. We are the owners of the show. So today we are giving you time to catch your breath. We are the originators of the show, so you relax.
Okay. So
I'll give up your everything.
Please go ahead.
Where did we start from?
So let's continue from.
Don't worry. Where did we start from?
Justice.
That was the first topic.
Former Chief Justice. That's the only topic we've discussed so far.
So what does she do now?
She's at the High Court now, challenging.
She's at the High Court or the Supreme Court?
The High Court.
I saw the Supreme Court.
No, she's at the High Court.
Judicial review application. She's at the High Court or Supreme Court? I can just check it.
We just spoke to the lawyer. I appealed to High Court.
He said at the High Court.
Yes,
okay.
yes.
All right. Well, you see.
But why are you giving
Madam, we started the show. You are just a tenant.
No, you were late.
You are a tenant. Now, Kwame Jantuah now originating panelist.
Yeah, you are the most. He's the most loved.
Now, as you know, the former Chief Justice she occupies a dual position, right? She's a Justice of the Supreme Court and also the Chief Justice. Now, some scholars and legal analysts have tried to create an artificial, I call it an artificial boundary between the person being a Justice of the Supreme Court and being the Chief Justice. But there's case law from Ajechum and others which have clearly stated that the grounds, but even Ghana Bar Association versus Archer, right? Kwame Jantuah, is that not the correct case? Yeah. Ghana Bar Association versus Archer, where the courts have held that in that Ghana, that's the straight thing. In that case, Ghana Bar Association sought to question the qualifications of the nominated Abad. No, it's just Ghana Bar Association versus Abad, yes. Abad, yeah. Saying that he was morally unfit to be the then Chief Justice. And the court responded through Mega GSC that what they were trying to do was to pass through the back door to remove the Chief Justice, because there's a constitutionally laid down procedure by which you can remove the Chief Justice. And so if the person is not competent to be a Justice of the Supreme Court, how does the person become competent to be the Chief Justice? The two are linked. You first must qualify to be a Justice of the Supreme Court before you qualify to be the Chief Justice. That qualification is the same. There's no set qualification for Chief Justice, and then there's a set qualification for what? For Justice of the Supreme Court.
But the provisions for the removal of a superior
That's why I said that you read the Constitution is not read in isolation.
Right.
We don't read the provisions in isolation. You read it so that it comes to makes a coherent. It gives coherence. You don't arrive at an absurdity. You read the provisions together so that you arrive at a conclusion that satisfies the purpose. So we call it the purposive interpretation. You understand? So if for example, in that same Article 146, in the Ajechum case, they made it a point that that provision, if you read it, does not make room for the need for a prima facie case to be made before the Chief Justice is referred to the committee. It's not there. But the Supreme Court read into that provision and said that if the other justices of the Supreme Court are allowed, or a justice of the Superior Court for that matter, before you can refer him or her to a committee, a prima facie case must be made. Why not the same for the Chief Justice? So they read into the Constitution and created that provision there so that there's a requirement for the Chief Justice to be what? To have a prima facie case made before you can seek to set up the committee to remove her. So yes, nobody challenges her right to go to court. I mean, it's for the intellectual exercise. I like it because as a lecturer, I want to know and see the provisions of the Constitution being tested. I mean, I have litigated everything under the Article 146. So if she also feels that there's a distinction between her role as Chief Justice and her role as a Justice of the Supreme Court, some may say that by and large, that particular argument seeks to probably preserve her entitlement, because then if she has come to the acceptance that she has been removed as a Chief Justice, why would she want to preserve her role as a Justice of the Supreme Court? It's basically because there have been all these years. And that's why a lot of commentators were like, look, in these kinds of situations, and she's not the first Chief Justice. Look, over the period, you've had Chief Justices who have resigned on health grounds. Right after a change of government in 2001, the then Chief Justice, who was the uncle that helped me, was it Aban? I think it was Aban. Aban was the one. Aban swore in Kufuor.
Yes.
After a few months, he resigned, right, and left. When, and there have been that, except for those who have died in office, like Chief Justice. There was one who died in office. Very progressive Chief Justice. He just didn't last long. He brought a lot of revolution in terms of trying to do the fast track courts and things. His daughter was my mate. I remember the name. He died in office.
As Chief Justice?
Yes, as Chief Justice, he died in office. See, the point is this. A lot of people felt that the writings were on the wall. And so there should have been a way that we could have, avoided this situation. But we have found ourselves in it. And so, well, let the case progress. As for us scholars, we welcome it, because at the end of the day, it enriches our jurisprudence. It tests the Constitution. The Constitution is a living document. It must be tested at all times. And so when you say rule of law, always take your matter to the Supreme Court, whether you like it or not. Donald Trump, who is seen to be adverse to the rule of law, he's always in court. That's the funny part. People say Donald Trump is the most lawless person in the world, but he has always, either he's in court or he's suing somebody, or exactly. He always, you see, you must get to the point when the Constitution is the same. Look, whatever you say about American democracy, you cannot convince me that the system was not set up against Donald Trump when he was a candidate, up to the point where he was facing about 6 trials or 4 trials at the time. Even though the then president would say that he had no hand in it, clearly there was an attempt to use the system against him. What was his refuge? The courts. He hired the best lawyers and went to court on everything. He loses some, he wins some. That is how the system should run. So for everybody, it is good if you it's good, yes, Justice Redu, yes, Justice Redu. If it's good if you decide that you are not satisfied with the ruling, or you are not satisfied with the conduct of somebody, and so you will go to court and test it. What we should not do is to bastardize the courts. That is one thing that maybe as we are growing as a democracy, we are only 30, 40 years as a democracy. As we grow, we will come to the point. Every system is politicized one way or the other. America's Supreme Court, as at now, is deemed to be very politicized. But they are the same court that makes rulings against the government and makes rulings for the government. We must get to the point when people must believe that the courts will deliver justice. You understand? So I'm happy that the Chief Justice herself believes that she will find justice in the court. So let's allow her to go and allow and respect her rights. I just feel that this situation was avoidable. From all the legal commentators, everybody who listens and says that, look, if she had resigned, because as it is now, I only see someone pushing to preserve whatever is left, because the argument now is no longer about being Chief Justice, but about whether she has been removed properly as a justice of the Supreme Court. Yeah, and why would you do that? Clearly, it's to preserve your legacy and whatever it is that you get out of it. So we pray for her.
Right. Now let's move on to our next conversation on illegal mining. I think on the show you've had so many conversations on the best way to handle illegal mining. Last week we heard from the president, who said a state of emergency should be the last resort. But this week, the Coalition Against Illegal Mining, UTAG, and the Catholic Bishops' Conference have all joined the calls for the president to declare a state of emergency. They are of the solid opinion that the way things are going, if nothing of that sort is done about it, it will not be good for this country. Lawuratu, I'll come to you. Some people say that the NPP lost the election last year because the NDC played politics with Galamsey. They called on the government to declare state of emergency. Samuel Okudzeto-Ablakwa, most of the cabinet ministers did so, but the song is different now, but the president says we are not there yet.
The shoe is on the other foot now, right? You know, one thing we always maintained, and Nii is sitting in the studio. I remember how he used to be very passionate about Galamsey. I don't know now, because it looks like most of them are shifting the goalpost. But one of the key things we all identified with was that the case or the fight against Galamsey, what we were pushing for was a collective fight. It wasn't a fight for an individual. It wasn't a fight for just the government. It was a collective fight for everybody who was part of the nation. And that is what our compatriots in opposition then, now in government, kicked against. To the extent that any time they were coming to a TV studio, a radio studio, they came with bottles of water. I doubt if the water in those rivers now will even fit in bottles now. They are virtually mad. You can hardly see the water. No, but if they had supported the fight then, without all that noise, without calling for state of emergency, without calling for all the things we were calling for, probably if they had all come on board, maybe we wouldn't be having the conversation as bad as we are having it now, because turbidity levels, one of the key things they used to use, are higher now. Ghana Water is virtually closing down some of their stations. I mean, I stand to be corrected, but turbidity levels are high now, and Nii will not admit it, but we know. But what the government of today needs to know, that we can't drink propaganda. We can only drink water. And their responsibility in government for the past 8 months and counting is to make our water body as safe as they wanted it to be when they were in opposition. You can't say one thing in opposition, you can't promise one thing in opposition, and come the priority they've given to the removal of the Chief Justice, the priority they gave to the setup of the Gold Board. I think that even if 1/10 of that urgency and priority is given to the fight against Galamsey, I don't think we'll be having a letter from Catholic Bishops Conference, the Media Coalition, and UTAG and all that. We've had them in the past, right? But they held us to the fire. What is different now? Why is there no urgency? Is it the case that the allegation that Gold Board is buying Galamsey gold is true? Because what really beats me, and I think we need to be credited with some level of intelligence, that you tell me that you are buying an item, but you only check the source of the item or where those you are sourcing the gold from after 1 year of purchasing them. What are you trying to tell us? Are they buying Galamsey gold? That is why we are having these issues. They need to be clear. It has to be a collective fight. What are the things? When the issue is raised, you see ministers and other government officials going and sitting on boats, on water bodies and all that. But when we were in government, the measures that we put in place were clear, and they poo-pooed most of them. The livelihood empowerment program, the gold catcher, provision of gold catchers, and all those other measures, where the reforestation programs and all that. All those measures we put in place, how have they built on them? If they haven't built on them, what sophisticated ones have they brought? The president said he was going to use AI. How far with that? But it doesn't seem that there's any agency that the government of the day is applying to this. Look at what the president said at the Meet the Press. And I maintained on another platform that if I were the IGP, and we as citizens should also be worried, that the president can publicly and boldly tell us that the police were moved from sites, Galamsey sites, because they didn't know what they were about. So the whole police system, the institution responsible for internal security, doesn't do any due diligence. They just get up and get into areas or operational areas and do just what they like. Then we all need to be worried. And I think the IGP needs to be very worried with his police chiefs. Because if this is how they are managing our internal security, then there's cause to worry. But in all this, I think that the same voices, the same tempo, the same requests they make, the repeal of the LI, the call for states of emergency, at least in 2017, there was a ban on mining, and we saw the results of it. In 2020, Nana Akufo-Addo was made fun of because he said he was putting his presidency on the line. We lost all the mining areas apart from one in 2020. And it didn't look any better in 2024 because of the pressure they put. Well, Galamsey was one of the key campaign points that the NDC. So what has changed? That our water bodies are moving from bad to worse, that excavators have virtually become like just doubling and quadrupling in numbers. It doesn't add up. And I think that the earlier the president kept to his promise in opposition and put some urgency to the fight against Galamsey. One of the things that used to come up strongly, and it's even becoming worse, did you see the statistics from Kolebu? Because kidney issues were becoming a problem. Those days, I mean years back, when they talk about kidney issues, it had nothing to do with children. It had to do with people with certain lifestyles. But now people are acquiring diseases that has nothing to do with their lifestyle. And it's because I just saw a post on GH1 that the contemporary and all those other healthy foods, as we term them, are now poison to our system. Yes, you put pressure on the government before. The people of Ghana thought you had a better option. Please let us see that option. We need to see it, because I mean, lives lost cannot be brought back, and I think that should be the priority of the government of the day, not removing heads of hands of government and all those other trivialities we are involved in. This is virtually, and in their own words, it's a national security issue and must be treated as such.
I think we all agree that there's something needs to be done to address this illegal mining menace. But Nii, is state of emergency the way to go?
Whenever I hear, this week I've heard President Addo, I thought he was going to be quiet and enjoy his retirement. But I hear he wants to be the campaign manager for the campaign of the NPP. You heard the way he said nothing good is happening in the country. I said, hey, God, how
I mean, your love for Nana Akufo-Addo is just too much.
How grateful I am that you've awoken President Nana Addo, because he must be the poster boy for the campaign for the NPP. He will make the life very, very comfortable for us. I think that you should keep him quiet.
You do feel
just like Dr. Always whenever I meet my NPP, I ask them how is Dr. Opoku, the vice presidential candidate. What is his name? He is
Napo.
Napo. They don't make Napo talk. I actually feel very, very sad that they don't allow Napo to talk. Napo should have held 1 or 2 lectures by now. Napo should have held 1 or 2 lectures by now. He said, when he was giving the interview, after the helicopter crash,
got to do with Galamsey? Let me finish.
After the helicopter crash, he said that.
You see the lack of
he said that the whole everything was due to pilot inexperience. When we were mourning, seriously mourning. This one was the vice president. Anyway, now you see. When we talk about state of emergency, I ask myself, the people who are propagating the state of emergency, have they looked at the legal framework within which the state of emergency, is supposed to be enacted?
There's no legal framework.
And what it is that is
How
to be
convenient.
asked. When we were in opposition, we made specific demands. You understand? TUC, in fact, the state of emergency was more in reference to an approach that showed a seriousness to deal with the Galamsey fight. You understand? It's state of emergency under the constitution is literally, as the president said, a last minute when the state believes that things have gotten to the point where if what we call martial law is not declared, we probably would. So, for example, you normally will see that an outbreak of a fight emerges at a place, and to maintain law and order over a certain period, you want to declare curfew, for example. So down to that curfew, 6 p.m. to 6 a.m. You restrict movement so that you can isolate and go in and sweep and get maybe people with arms, illegal arms and all that. You want to restrict movement to allow the security forces to be able to deploy, among others. So it is normally a last resort. But what you want is a combination of actions that shows the state's seriousness in dealing with a particular problem. In the NPP era, understand, the reason why civil society and everybody was up in arms. Number one, you had a situation where these caterpillars, or what do you call it? What's the name? The excavators.
I know you've forgotten the name, Nii.
Excavators. You understand? That's why my uncle is there, to give me support. Excavators were unaccounted for. There was no system of tracing and accounting for the excavators in the system. Is that the same situation today? No. You cannot import an excavator into this country now and it will be tracked. You must show where you are taking the excavator. There are trackers on it. That's why you are able to get 400 or 500 excavators under the security agency's watch. They are accountable. You can go with a freedom of information request, and they will show you where all the excavators are, the ones that have been seized. What did we find in the NPP time? Auctioneers, what do you call it? Party officials who were registered as auctioneers were selling these excavators. They were selling them. There's evidence of bank accounts that were used for the sale of these excavators. That's the legacy that President Nana Addo left. His own party officials, regional chairman and so, were involved in illegal mining near water bodies. And what did you find? The president. In fact, that was the saddest day. When I saw that, then I gave up hope in that government. The president mounted the stage and defended Akunta mining. The president, a company that had been told, or we had been told was involved in some form of illegal mining on water bodies and in forest areas, without an investigation, let's even say Yoko, whatever, the president mounted the stage and said there's nothing like that, whitewashing his regional chairman's company. That was the level of impunity. If you have presidential cover, you understand, how do you fight Galamsey? In the opposite is that our president has directed Yoko to investigate 2 national officers of the NDC who are alleged to have been involved in illegal mining. They are going through the process. We have excavators that are being tracked. The LI, which gave President Nana Akufo-Addo, he sneaked it into parliament and gave him the authority to authorize mining in water bodies and in forest areas. In forest areas for that matter. And that power was for him alone. He didn't even share it with the minister. How many licenses did President Nana Akufo-Addo under his signature issue with respect to that LI? Today, the current president has ordered that when in fact, number one, President Muhammad has not signed since he came into office 1 license authorizing mining in forest areas, not even 1, even though he has the power under the LI. The second point is that in October, under a certificate of emergency, that LI is going to be repealed. How can you compare this record to this one?
Has that everything that you've said, the government has done now, has that improved the situation?
Yes, if you look at the Water Resource Commission reports that came out, they take their measurements twice in a year, the dry season and the wet season. You can see that in a number of areas, the turbidity levels have improved. It's not all areas. But the thing is, there is an ongoing fight. The secretariat that has been set up, which is integrated in terms of the management and coordination of the fight against illegal mining, is not the center where money is distributed. Apologies to my brother. He's a very good friend of mine. The one that was collecting the tea at the he was collecting. It's not the center where you see ministers. You won't hear any NDC minister telling you that party didn't hear ska. There was a recording of an environmental minister in an environmental minister's office where there was the conversation that because the party needs money, illegal mining must be allowed. Party didn't hear ska. You see, that's the level of impunity that was exhibited in the NPP government. But anyway, we've thrown them out. So that's the message that Lawuratu will tell us that, yes, they were the bad ones. They've been thrown out. So what are we doing? That's the difference. The difference is the approach. If it becomes necessary, you understand? If it becomes necessary, President Mahama has no shot. See, the difference between President Mahama and President Nii Kpakpo Samoa Addo is that President Mahama is not fighting for a second term. So he takes decisions not based on feelings, emotions about whether he has no second term to fight for. So he's dealing with this fight in a gradual manner. He's deployed the armed forces. Just last week, if you looked on social media, you see pictures of the fights that has been taken simultaneously in all the areas where we've had re-emergence of mining in illegal mining on the water bodies. The shamfines are being destroyed. That's why we can't use it. So those ones, the order is to burn them. But the what do you call it? The water pumps are being redistributed to farmers. We seize them, we redistribute them to farmers. The excavators are being escorted to centers. It is a fight. We are in a fight of our lives. No two ways about it. If it becomes necessary, President Mahama will declare a state of emergency.
At what point will it become necessary?
But he believes that at this moment, the combination of factors that are going into this fight, it's clear that we can win the fight.
At what point would it become necessary?
We don't need, so I said that we haven't gotten to the point where we must declare a state of emergency because there are a lot of things that are being done. You understand?
Like
that. Why? Now, why you are not listening? I can understand why you are not listening.
A lot of things
are they enough to get
registration of excavators? Should excavators be coming in the first place?
Lawuratu, are they enough measures to get us the results that we need? We need our water bodies to clear.
This is an 8-year problem you are dealing with in 8 months. We have been in power just for 8 months.
Galamsey was there before.
Oh, please.
Galamsey was there before.
Galamsey, but not within the last 8 years. The problem you are facing today is as a result of the negligence of the past president and his government. Why they decided to sit down and criminally. And I'm happy that the Attorney General has indicated that he is going to prosecute some of the kingpins who have been involved in this illegal Galamsey. Yes, we are going after and it was in our manifesto. We are not joking about that issue. We are going after the paymasters. Not those boys who go in to wash the gold. We will be going after, and he has indicated that the Akunta mining case will be the first time where you will see a public officer, a politically exposed person on trial for illegal mining. Now we are not going for the small boys. So those who come to the studios and display gold chains and what have you, and claim that is where they got their money from, they will answer in court. When you see that you are going to face 10 years in prison for those kinds of actions, then everybody will wake up that, oh, indeed, this government is not joking. We will not allow party officials to benefit from the destruction of our environment. It will not happen under President Mahama's time. They used 8 years to destroy. What they have damaged in 8 years, they expect us to repair in 8 months. That is ridiculous. They should not even be heard commenting on this issue. 8 months, and look at what we have done as compared to what you did in 8 years. And you want to compare yourself to us and ask us, you don't even have the moral right to talk. You have to keep quiet and let us govern this country for 4 years. In the 4th year, then you come back and be asking questions. Uncle Jantuah, take over.
Have they done enough within 8 months? Some say, I mean, 8 months is not enough for us to be calling on the president to state of emergency. What they have done so far, the repeal of the LI, which will be going to Parliament when Parliament resumes, and the blue water guards, the tracking of the excavators and all of that. Are these measures enough?
Gemma, Galamsey is a drug war. The drug war that you see in South America, how is it fought? Don't people die? This is our drug war that we've allowed for it to travel a certain distance. I think that distance has been traveled in such a way that it's not it can be, it is detrimental to the sustenance of our country called Ghana. For me, this is my opinion. I believe there should be a state of emergency on our water bodies, if for nothing at all. If for nothing at all. Why? We've seen animals, sheep being born with 2 heads. We've seen deformed fetuses. We've seen how the soils are devastating in those areas, are devastating to the people who live there. The kind of diseases that we never used to have, they are having today. The fact that our water bodies are laden with chemicals. The fact that those who are doing Galamsey are diverting rivers and Cobra. They're diverting it. And most of all, if there's a state of emergency on our water bodies, Shangfans are not being imported. Shangfans are what? Are manufactured here in Ghana, are fabricated here in Ghana. The moment you put a state of emergency on our water bodies, that Shangfan that is being built would have to stop. Where will they be taking the Shangfan to? And let's face it, what is the main ingredient of Galamsey? Apart from finances? Water. Water. Fresh water. Fresh bodied water that we use for potable water. That, you know, the water people use to refine and then treat and then give us potable water. So for nothing at all, I would like to see a state of emergency on our water bodies.
Would that solve the problem?
It will stop the mining of gold on our water bodies.
For a period. Because you cannot declare state of emergency forever. How is this
till
supposed
such
to
time
work?
that the turbidity of the water starts coming back? Such time. Because right now, if we are not careful, the water is going to kill us, and we would have to find money to import water. We are heading to that point. We are heading to that point. And for me, mine is the water bodies. I'm not really concerned about, onshore mining. That one we can handle. But for the water bodies, water that is life. Look, it is so sad when you fly entering Takoradi and you see the water streaming into the sea, brown and muddy. It is sad. It is sad. So for nothing at all, for me, that should happen. Then when we come to the protection of trying to make sure that some of these things are policed, the president talked about, is it the blue guard? Is that what they're called?
Blue water guards.
Blue water guards. I remember initially during the former government, in the early days, some of us said, we are creating a certain situation where those doing illegal mining would try and protect themselves. Because I looked at South America, and you see, the South American one is manufactured. Cocaine is what? Manufactured. Here, ours is not manufactured though. Ours is part and parcel of God's gift to Ghana, gold. Now, if they see you attacking them, what will happen? They would want to defend themselves. Are the Galamseyers not defending themselves today? Are they not? Don't they have weapons? Are they not killing? And the Blue Guards are supposed to do what? They are supposed to be whistleblowers, right? Right now, if one of the Blue Guards is killed, what would we say? Is shot. What would we say? Even if the person is maimed, what would we say? We need to fight boot for boot. I would want a situation where the president would take a certain section of the army, train them well to face the Galamseyers. 4 million people, apparently, is said to be in Galamsey, as against 33 million, or you take the 4 million out of it and say 29 million people, and then we sit for them to overrule. No, let's fire them boot for boot. Fire them boot for boot. It was a good thing what the president said with regards to being able to send some people to Australia to be able to learn how to do good, practices of mining. But I think it should be the other way. They should let the Australians come here and teach a much wider group of people. Much wider group of people. I guess what the president was trying to refer to was that train the trainer. They'll go, they'll learn, and then they'll come and train. Do you think it will happen? Do you think it will happen? So the Australians should come and let the Australians sit on TV. Let the Australians come to radio stations. Let the Australians go to all the different institutions and talk about it. This is how it's done. This is how we should be doing it. This is what you do that makes it wrong. So that at least, if for nothing at all Ghanaians get to hear. But don't we have a system in the agricultural sector where we have cooperatives? Are you saying in Ghana we cannot turn Galamsey into cooperatives? Because you see, Gemma, the entire stretch of Ghana is covered in gold. Topsoil gold, alluvial gold, deep mine gold. The entire stretch, left, right, center, is covered in gold. That is why we were called the Gold Coast. We are called the Gold Coast for nothing. It's covered in gold. So it's a good business. But we have to structure it. And we need to take certain decisions that are hard. That can affect probably the politics of a party. However, if it is done more collectively, it is done as a national issue where politicians don't argue amongst themselves, where politicians say, when we were in government, we did this, we did that. But to sit and think together and say, this is what we think we should do collectively as a country because it's a national issue. Won't we go far? Won't we go far? I expected at the time, and I said it, I expected that President Akufo-Addo would have called leaders, past presidents, chiefs, sat down together, round table, came to a decision, this is the way we are going, so let's go that way. It didn't happen. I still expect President Mahama to do that. Because the past presidents who we have today have experience of Galamsey the same way they have experience of Dumso. They've been through it. And it would be sad if he gave an olive branch like that and none of them decided to take it up. Because they are the elders in the country. President Kufuor is a statesman. President Akufo-Addo is a statesman. Otumfuo Osei-Tutu is a statesman. All these, revered people can sit together and say, this is the way we go. What did the speaker say? The speaker said, we know some of you people in parliament who are doing Galamsey, you've got to stop. Have they mentioned their names? Otumfuo said the same thing in a gathering. We know those who are doing. Have they said anything about it? And what is even most surprising to me is that between NDC and NPP today, has any financier been arrested? It is not only the political ones like Chema to me. There are others who are financing it. And you see,
he says the government is going after them.
Well, no. You see, it's not a question of you. It's not even whether the government is going after them. Please, my dear, it's not even that the government is going after them. Publish their names and let public pressure deal with them. Publish their names in the newspaper. 1, 2, 3, 4, 5, including politicians. And we should have, Parliament should pass legislation, irrespective of majority or not majority, and probably this is where the politics comes in. If you, a politician, and a parliamentarian, is seen to be doing Galamsey, you lose your seat.
That would be when the court finds you guilty. Is that not the case?
Whatever the case is.
Publish their names before, or
let them publish the names and let them come and defend themselves.
But that's what they promised.
Let them come and defend themselves that I am not in Galamsey. Let them come and defend themselves. Because, and you see, the Electoral Commission too is not being helpful to us. Because the Electoral Commission should be able, they have the mandate to find out how political parties are financing themselves. It is their mandate to do that. If I'm not sure which of the CSOs brought out the study that to be a president in this country you need 200 million.
CDD, I think.
Who earns 200 million in this country apart from private sector? Who? What politician? Does that not bring out a situation where the question should be asked, how do politicians finance themselves? And should we not delve into it to find out how it's done?
You suspect it comes from illegal mining?
Oh, it's part and parcel of it. It's part and parcel of it. Let me ask the question. I applaud the Gold Board. But the Gold Board has been in place for how long? 6 months?
Yes.
6 months. Between the time they've been in existence and now, how much have they said to be? How much have they made? $6 billion. Huh? And part of the gold that they have been able to acquire has supported and chalked up our reserves in the Bank of England. Are we saying all that gold that has been sold by the Gold Board is from small-scale legal mining? Is that what we're saying? Let's call a spade a spade.
That's not the case.
Let's call a spade. Let's call a spade a spade.
But we heard the president say that even if we are going to get something, even if it comes from illegal mining.
And I'm saying let's be truthful. You see, the challenge is that we need the money. The country needs the money. But for the country to need the money, let's make sure that we put Galamsey in a good structure. Let's put small scale. Are you trying to tell me that those people with small scale mining licenses, they don't do Galamsey? Is that what we're saying? I don't believe that is so.
But why would they do Galamsey, illegal mining, when they have the certification and all the documents to do proper mining?
Ask them. Because the licenses that they have, those licenses aren't meant for water bodies.
Right.
Those licenses are meant for the concession they've given you. And if water bodies are easier, they go do it. It's illegal. Look, the previous government brought a system where you get gold from rocks, right? Where they brought machines and all that. What has happened to that? Have they themselves, the previous government, what they brought, have they themselves been able to account for how much gold we got out of that? Have they been able to? Did it work? I think where gold is concerned, and Ghana gets most of its revenue from probably 3 resources we have: gold, oil, cocoa. Number 1 is gold, number 2 is oil. And oil because we haven't done exploration to production in 8 years. The whole of the NPP administration, 8 years. How much oil did they do?
They were fighting. Sharing and fighting.
How much oil did they do? And you see, Oil is one commodity. When you compare all the other commodities, oil is one commodity where the money just comes in, boom, comes in plenty at once. We didn't do.
Tell Ghanaians what happened. Why were we not able to drill during their time? What was happening? Tell Ghanaians.
You are in government.
I won't go down that line.
This propaganda.
Mine is.
You can't govern a state with propaganda.
Mine is to make sure that we do things right. Look, Gemma, if it so happened that we were able to put Galamsey in the right state, we have cooperatives, it's done well, I will go into it.
I think the state should take over.
I would go into it. Why gold if it's done well? Why are South Africa, and I'm not saying that there's no Galamsey in South Africa, but how come South Africa has been able, some of the provinces in South Africa have been able to benefit from their gold? Do you know that Ghana gold has made a certain province in China rich? The gold we have here. Gold we have here. So it should be structured. I think one of the major challenges government has today is that no matter what you bring in, the people won't stop. No matter what you try and bring in, the people won't stop. So you've got to find some incentives that are attractive enough for them. But what can be more attractive than gold? So the only thing you've got to do is to structure it well. And you've got to be able to explain to them, if you're stopping the production for a short duration of time to get things back up, you've got to be able to explain that to them, for them to understand. You think the people who are doing the muddy work, and you think they're happy doing that type of job? They're not happy. But what can they do? So we've got to have a situation, because you see, the mere fact that agriculture is a huge basis for this country. Without good soils, forget your agriculture.
Forget your cocoa.
Forget everything. Without good soils, forget everything. Yeah. We are all dying slowly. Slowly. Our cocoa, our nkontomre, our okra, our what you got. Maybe there's one place where this thing won't be affected. Maybe the Volta region. Because there's no Galamsey. But to some way or means, water travels and finds its own space. And maybe we should thank Kwame Nkrumah for creating the Volta Dam, a river that was turned into a dam. So we have plenty fresh water in the Volta Dam, and probably that will be the last bastion to provide fresh water for us. But it shouldn't be so. It should not be so. The people of the Western region are the ones most affected. The people of Ashanti are the ones most affected. The people of the Eastern region are most affected. Those concentration points, I would appeal that in as much as the president has said we haven't considered and done so many things, at least the water bodies in these areas, there should be state of emergency. Right. Lastly, to add, I also think if the Gold Board has been able to make such amount of money in such a short duration of time, and this is just an appeal, a certain percentage of that money should be given to the water people to be able to purify our water. Because without water, we are all finished. Can you imagine? And let me use this example. It might not sound well in the ears of people, but can you imagine your sanitary, what do you call it, in your home is choked with feces and you cannot flush your toilets? Can you imagine? Can you imagine the stench in that? Can you imagine the unhealthy situation that can create? So if for nothing at all, the Gold Board gave them 5 million cedis and how many pickups? The certain portion of that money should be, and if it's going to be given to the water people, we should police the water people to make sure that they are using the money properly. There's a problem there in terms of management and how they handle finances. It should be policed very well. Reports should be given to the people at any given stage. Lastly, they should be able to identify, and I'll finish here, they should be able to identify how Galamsey water and which parts of Galamsey water is polluting our water bodies. So that the money they give is specific for that. They can't come and tell us any other. Specific for that, but it has to be policed well.
Right. Gemma, just a quick one. Talking about the water and sources of water. Look, where I live, we used to get latter part of, let's say, 2024, we used to get at least twice in a week flow of water from Ghana Water. So other days you have to buy water. When I moved there 2 years ago, we were buying water, a tank for 130 cedis. As at March, we were buying it for 150.
But do you know where that water is coming from?
150.
Do you know whether it's potable?
It's from 150. As at March. Now we are buying it for 250. How many people can buy water at that price? And it's even going just whatever. But we should also think about the health. So if people can get water, they use all kinds of water, and that's what brings cholera. And we need to be careful. But you see, in all this, we can talk about what past administration did. But if Nii sits here and tell me it's ridiculous for us to see some of these things, and what he's telling me is that apart from now the president said what for hate speech and all that, they are going to be using IP addresses. Nii is now telling me in fighting the case they are going to go to people in what gold chains. I mean, if there's anything ridiculous, that is what is really. Look, during President Akufo-Addo's time, we said arrest the people in the act. Financier. They said no. Don't arrest those people, arrest the financiers. Who are the financiers they've identified? The excavators, they say they are registering and tracking. Who are those bringing them in? They said they are putting trackers on those excavators. Where are the excavators going now? Now it's become a whole market that states now has to spend money relocating excavators because they are taking space at the port. They should live to their promises. And look, the training that His Excellency the President is saying, I think that's far-fetched. There's been a lot of training. There's a project called Planet Gold, teaching small-scale miners responsible and sustainable mining. It's been going on. The Association of Small-Scale Miners, they've been collaborating with UMAT. So what are we going to Australia for? But you see, when a government leads its issues with populism, these are some of the approaches they want to use. What suddenly happened to the recommendations they were making? If they were not just for populist and propaganda purposes, why can't they implement them now? Mr. Jantuah is known for shoot and kill. He's been consistent with at least having a state of emergency on our water bodies. But when you talk now in a democracy, new owners of Ghana say that we should shut up. And he said that we should keep quiet.
They're not owners, they're leaders.
Well, they're servants actually. Nii says we should shut up or we should keep quiet. I mean, who does this? Right. Mr. Jantuah is talking about we working together. How do we work together if you are telling us to keep quiet or shut up?
This is my sister. When Nana Akufo-Addo was in power, she cannot come and sit here and be pontificating.
I was coming here
coming to talk about
telling you it was a collective fight, which you refused.
You couldn't even tell President Akufo-Addo that we beg you. You, the one that you have allocated to yourself, the one that you sign, and the licenses. You were signing. Listen, this is somebody.
Constituency chairman going against government.
Please,
government.
This is a president who allocated. This is the first president who has allocated to himself the right to sign mining leases in forest areas, and he signed that in the last day. That is the president that today he says what?
You sitting at Cocoa Board and you are not talking about Galamsey.
Okay, so Christopher Abe says since the government has shown clearly that gold is their main reason for coming into government, Ghanaians need to take the fight to the Galamsey, as we have talked enough. Okay. I cannot read the rest of the messages. But
it's for Mr. Jantuah.
Read it.
It's for Mr. Jantuah.
No, it's actually funny. Yes.
It's for Mr. Jantuah.
We are used to it. Read it. We don't mind. Read it.
So Baba Chairman says Nii, a perfect gentleman, being unfortunately turned into a political gymnast. And then
Nii just been acrobatics here.
Let me just end it there. We were supposed to speak.
So we can go on.
Yeah, we were supposed to speak about the thank you tour of Esiedun Ketia. I'll do very briefly. Nii, so there's talk that the national chairman has a presidential ambition, and he's using that thank you tour.
Have you heard him open his mouth to say he has a presidential ambition?
So
you are looking at him and you like him. So if you say that he has,
I never said I like him.
Nii, say that you like,
say
that you like him, and you think that he has presidential. He looks presidential.
Does he look presidential to you? I'm just asking.
Why he doesn't look presidential?
Does he have a presidential ambition?
Why?
Does he have a presidential ambition? I'm not a member of the NDC.
So you are talking. You are introducing the topic that he allegedly has presidential. Some say
yes.
Who has said that?
So Ras Mubarak pointed out.
He has an opinion.
He
disagrees with the thank you tour, and he expresses his opinion. That's the beauty of democracy. Yes, you can have an opinion and you can express it.
But the president finished his thank you tour.
But didn't you see the way we ran our campaign? Our campaign was not run. We didn't have a limping president who could not go out there campaigning. We had a presidential candidate who was campaigning. We had the national chairman who led the parliamentary run, and that's why we have how many seats in parliament. You understand? The chairman led the parliamentary wing of the campaign. We had the presidential. But why? Were you not defeated in the election? You are still not woken up. So if he finishes and he decides that, let me go around and touch base with, because our party is structured, all parties. It's only the NPP that starts presidential primaries before going down to constituency elections. The correct approach by every party is that after the election, you take a break, you do your assessments, then you start rebuilding. So you start from your branches. They have police station, we have branches. Then you go to your constituency. Then you do your wards. Then you come to your regional. Then from the regional, you go to the national. After that, then you look at the presidential elections. That's the structure over the past 30-something years since we started in 1992. It is only the NPP that has reversed it because they only want one person.
How does this
please,
NPP?
Please, to win. Me? Please, let me finish. I don't interrupt you. Now, we have our national chairman who, as the national chairman of the party that has a super majority in parliament, and the presidential candidate who dismantled their beloved Dr. Bambia, the economic messiah, by over 1.7 million votes, has decided to do a tour of his branches. That is the base. He is going there to reassure our base that I sit as a branch chairman. You understand? And so when I see my my chairman coming to reassure my men, because when you win, after they win in an election, the next thing is pressure. There's pressure for job opportunities, there's pressure for educational opportunities and all that. So you need the chairman coming around to reassure the party base that, look, we have not forgotten about you. The promises that have been made prior to the election will be manifest. People will get the opportunity to join the security services. Educational opportunities will be made open. Scholarships will be made open. So your fight for the party to become victorious was not meaningless. At no point during this, this tour, has he declared a presidential ambition. In fact, he has warned that the success of the Bahama administration is what will guarantee the victory of any presidential candidate. So I don't know where, and the thing is this: if you haven't declared yourself an intent to stand, nobody can declare for you. But if you look at the person and the work that he has done, and you believe that the man is deserving of being a president, that's why you can't stop people from admiring him. Do you understand? So you can misinterpret You have to go with. That's why there are media people who have followed him on this tour, waiting for him to say one thing, just one, that he is standing for president. Hey, then they'll pick it up. He has disappointed you. There were media. In fact, I've seen that everywhere he goes, there's a live transmission of what he says. And he has not, because Mr. Seydou Ketia is a very old politician in this country. He's been a former MP. He's been a former minister. He has run both as party secretary, general secretary, party chairman, both in opposition and in government. He is overqualified if he decides that he wants to stand. But the point being that he knows and measures his words carefully. If there's one politician who measures his words before he speaks them, it is him. And he has stated clearly that under no circumstance will anyone try to declare too early, because when you do that, you take the focus away from the government. Right. He will be the last person to do that. So as for our NPP friends, instead of going to help campaign, the campaign that has consumed the Baumia campaign, where we are now finding X, she is busy here trying to instigate. I
can identify with Nii's excitement, but if it looks like a duck, swims like a duck, quacks like a duck, you can continue. Nii can sit here and say whatever he wants to say. That's up to them. That's their business. But it's just curious that a president that has a mandate of 4 years, he said he's not going to seek re-election. I thought it was a given. There was no need for an announcement.
You held a press conference that said that he was packing the Supreme Court.
You shouldn't interrupt. Stop interrupting me. Right. There was no need for that announcement, but it was made anyway. Because, the same constitution they are using against the Chief Justice, the same constitution that says you go for 2 terms. So there was no need for that statement. But, it's nice, reassuring, because of what they themselves think. But you see, in less than 1 year, you have close to 12 people wanting to succeed the president.
12 people?
Yes, because Musah Danquah brought out.
Musah Danquah is a member of the NPP.
Brought out a list. Right?
This was 4.
I heard him even warning them that when he was doing polls about the NPP, nobody threatened him, so they shouldn't be threatened. But that's the NDC for you, revolution tendencies. But you see, 12 of them, and he was explicit that none of them has protested why their name is there to run the poll.
A poster puts up this there, then you should go and protest.
Look, if your mother is dead, you say she's sleeping, dawn would definitely come. Night will fall. It's up to them. It's their business. Whatever they choose to do with them, we are focused on rebuilding our
re-electing Dr. Baumia
and coming back strongly for 2028. Whatever they choose to do with all their propaganda, with all their PR and populism. Nii can sit here and shout. It's obvious that he's supporting his chairman. And you can't blame him. It's chairman solidarity. He's branch chairman. Nii doesn't finish this show without telling us he's a branch chairman. So it's up to them. Whatever they do. But what we want them to do is focus on fulfilling the promises they made to us and making our nation better. None of us. That's why we all come to the conclusion that there's no campaign after election. They should fix the country that they said was in tatters and stop all these gimmicks. Whatever they choose to do, whether they are marching with the general, whether they are dancing and walking with the chief of staff, whether they are dancing with Gando, whether they are forcing with forcing, that is up to them. They should fix this country and make our economy better. That is the contract they have with the people of Ghana.
Gemma, isn't it mediocre for us to make that a central discussion? Isn't it mediocre? Can't anybody declare that they want to stand?
Exactly.
When there are
why they denying
issues we need to discuss. Saseedun Ketia, who is going on a tour, and we think he's going on a presidential tour, so it has become topic. It has become topic. For me, it's mediocre.
It's neither here nor there where I'm concerned.
Mr. Jantuah.
Neither here nor there where I am concerned. And are they trying to tell us? And the media is part and parcel of this kind of, talk. Are they trying to tell us? And I'm sure we'll hear down the line that Asaase Nketia is at loggerheads with the president. That's why he's doing what he's doing. Are you trying to tell me that Asaase Nketia and the president don't have a good relationship, and that whatever Asaase Nketia would do, he would not consult with the president? We should stop this kind of politics that we play. There are dire consequences in this country we need to take care of.
Mr. Jantuah for president.
Let's stop that kind of thing. Let's stop it. There are people who don't have food to eat. There are people who don't have good housing. Galamsey is killing us. We are under an IMF. There is no money in the country. Please, put that aside. Put that aside. Look, all the NPP people who are standing, one of them would win.
Yeah.
One would win. Anybody who wants to stand for NDC, one would win.
CPP.
Mr.
Jantuah for president.
Would win. However, we should always make sure that that person who wins can win the country.
Right.
That is where the challenge is. So let's stop this kind of thing that we are talking about. Let's be concerned about the issues this country is going through and how we can make this country better for everybody. What is happening with deportees from America? Why are people going? Why are we losing our great talent to other countries? Those are the things we need to talk about and stop this thing that Asaase Nketia is going to stand for president ABCDE. It's not here nor there.
Thank you so much. You just had lawyer Kwame Jantuah. He's a member of the CPP. It's a holiday on Monday.
No, it's tomorrow. Monday is a holiday.
Yes, the holiday is on Monday.
Tomorrow.
Yes. Okay. So Lawuratu Musah-Saaka, a member of the NPP communications team, thank you so much for coming. And Nii Kpakpo Samoa Addo is a lawyer, branch manager for the NDC. We were joined on, branch chairman. We're joined on Zoom. It's a branch chairman. Osford Osei Bonsu, a lawyer, joined us on Zoom, and also Ayiko to a lawyer for the former Chief Justice, also joined us on Zoom. Alexander Ban also joined us on Zoom. Thank you so much for listening. My name is Gemma Appiah. Thank you for watching. Like, comment, share, and subscribe.